would like to call to order the August 31st, 2020 meeting of the Charleston County Board of Zoning Appeal, also known as the BZA. Second slide, please. Ms. Working, can you please go over the virtual meeting protocol?
Yes. Staff will control the slides displayed throughout the meeting. Applicants and members of the public must be sworn in before speaking for the first time. They should state their full name and current address for the record. Only attendees who have registered to speak before the deadline may speak during the meeting. Applicants and/or their representative for the public hearing cases are registered to speak. Video and microphone have been disabled for all attendees. Attendees will only be given the capability to speak when they are called on by the BZA secretary or chair. If you submitted a request to speak on a case before the deadline, staff will call your name when it is your turn to speak and will enable your microphone. Your microphone will be disabled after you are done speaking. Chat has been disabled for everyone. Board members who need to recuse themselves from voting will be temporarily removed from the meeting and re-admitted prior to addressing the next item. And this meeting is being recorded.
Mr. Sala, next slide. Ms. Working, can you please call the roll for the BZA members and introduce and swear in the Charleston County BZA Planning Department staff that are here and present today?
Okay. BZA members, when I call your name, please say here or present. Mr. Ray?
Here.
Ms. Lechner?
Here.
Ms. Allison?
Here.
Mr. Boykin?
Present.
Mr. Freeman?
Here.
Mr. Goldstein?
Here, but technical difficulties. How do I turn up the speaker?
You sound really loud.
Oh, I can barely hear y'all.
Okay, well, you sound good. Okay, so
Okay.
Mr. McConnell?
Here.
Mr. Nelson?
Here.
Mr. Woodall?
Here.
And the attorney for the BZA, Mr. Kelvin Hugie?
Here.
The Charleston County Zoning and Planning staff present for this meeting are Joshua Downey,
Here.
Edgar Sada,
Present.
Jennifer Stiles,
Present.
and I'm Jenny Working. I'm the secretary for the BZA. At this time, I'm going to swear in the staff that will present testimony or evidence. Staff, please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
I do.
Thank you.
Next slide, please. Because the hearing tonight is a public fact-finding meeting, we are in compliance with the Freedom of Act and South Carolina Code 6-29-70. 15 days prior to this hearing, an announcement was printed in the Post and Courier. A sign was posted on or near the designated property, and a notice was mailed to the applicant or the applicant's representatives, to the property owners within 300 feet of the property, and to parties in interest. Persons, organizations, and news media have also requested declaration of our meeting and have been notified. Board members, the meeting notes for July 6, 2020, and July 20, 2020, public hearing were mailed to you. Are there any changes? If not, may I have a motion to approve and a second?
So moved.
So who made the motion, please?
Mr. Nelson.
Who was it?
Mr. Nelson.
Mr. Nelson. Okay. Thank you, Mr. Nelson. Do I have a second?
Second.
All right, I have a second. So now I'll bring it to a vote. All in favor, please say and indicate by saying aye. Aye.
Aye.
Any opposed? It's unanimous. Our case ruling from this and any BZA meeting are available to the public viewing and inspection during normal business hours at the Charleston County Zoning and Planning Department. Next slide, Edgar, please. The Board of Zoning Appeals is a judicial body that has final decision-making authority. Appeals on zoning-related administrative decisions. The BZA is authorized to hear and decide appeal only on zoning-related matters where it is alleged that an error has been in order. Requirements, decisions, or determinations made by an administrative official, in the administration or enforcement of any zoning-related regulation. A 2/3 vote of a quorum present is required to overturn the decision of the planning director in an appeal. A special exception is an exception issued by the BZA authorizing a particular use in a specified location within a zoning district. Upon demonstrating that such use complies with all conditions and standards specified by the Zoning and Land Development Regulation Ordinance, ZELDAR, the BZA must find that the special assessment exception requests meet all 6 of the approval criteria in the ordinance in order to grant a special exception. A simple majority is required to grant a special exception. A variance. A variance is a relaxation of the BZA of its regulations of the ordinance where such actions will not be contrary to the public interest and where, owing to the conditions particular to the property, and that the result of their actions or the situations of the applicant, a literal enforcement of the code, will result in an unnecessary and undue hardship. And such variance is consistent with Section 6-29-800 of the Code of Law of South Carolina. Title 6, Chapter 29. The BZA must find that the variance request meets all 7 of the approval criteria of the ordinance in order to grant the variance. A 2/3 vote of a quorum is required to grant the variance. Next slide, please. Our purpose tonight is for interested parties to be heard in order to assist the board in gathering evidence pertinent to each case. If a member of the BZA feels a need for further information to clarify a case, the board has the authority to subpoena witnesses. It is understood that the rules of your neighborhood or subdivision are binding and that we can take no actions to negate their jurisdiction over the property. In addition to your testimony, our board has presented written information submitted to the staff by the applicant or the applicant's agent for each case. This information is now considered to be evidence and is entered into the permanent record of the body. It is assumed that it is complete, true, and accurate. In addition, we have presented data assembled by the staff for the purpose of clarifying the location, the applicant's effect on the surrounding property. Our board is empowered to approve with conditions, or to deny a special exception or variance request. We are also authorized to defer a case should there be a need to obtain additional information. The BZA's final decision will be mailed within 10 working days of the public hearing. It will be mailed via certified mail to the applicant and via U.S. mail to the neighbors and the community interested on the list. If an applicant request is approved, the applicant should contact the Charleston County Zoning Planning staff to discuss the next steps in the process. Variances and special exceptions granted this evening are valid for 12 months after this meeting, and 1-year extension may be granted only if construction or development has commenced or being diligently pursued. However, if an applicant request is disapproved and the applicant wishes to appeal the decision of the board concerning this case, an appeal must be addressed by or to the circuit court. South Carolina Code 6-29-820 states that the appeal must be filed by the applicant within 30 days after the decision the board has mailed after the board is mailed to them. Failure to file an appeal within a time limit deprives the court of its jurisdiction to hear this matter. Because it's judicial body, everything said in this meeting must be complete, true, and accurate. All the information provided to this board is considered evidence, and the board may certify contempt of circuit court if a false statement was made, either in writing or orally. Each person who wishes to address the board will be sworn in by the BZA secretary before they provide testimony or evidence. Next slide. I will now call each case by case number. Staff will present facts pertinent to the case, limited to 5 minutes. I will then call the applicant. The applicant will state his or her name and current address for the record before presenting testimony pertinent to the case, limited to 5 minutes. I will then ask for those speaking either in support or in opposition of the case, and then will follow the same procedure to identify themselves, and are limited to 2 minutes each. The applicant will then have the chance to reply to any opposition, limited to 2 minutes. And then the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application, state specific findings of facts and conclusions of law. Tonight, we'll hear 3 old business items and 7 new business public hearing cases. Next slide. Ms. Working, can you introduce the first request for reconsideration tonight?
Yes. Let me see. Am I unmuted? Can you guys hear me?
Yes.
Okay. This is old business item number 1, request to reconsider case number BZA-05-20-00401. Per the BZA Rules of Procedure number 20, upon vote of the BZA, a member from the prevailing side may make a motion to reconsider a case at the same or next BZA meeting. Any member may second the motion. If the motion to reconsider the case is granted, then the case will be scheduled and heard by the BZA at the same or next available BZA public hearing, provided all required notifications have been met. A case may be reconsidered only once. Public comment is at the board's discretion. There is generally no public comment for the motion for reconsideration unless the board requests public comment. If a motion to reconsider is made, the BZA's decision stands and the party may appeal the BZA's decision to circuit court. Final decision and orders for the July 20th cases were mailed on July 31st. Any person with a substantial interest may appeal the BZA's decision to the Circuit Court of Charleston County within 30 calendar days after the decision of the BZA is mailed. If a motion to reconsider is made and passes by majority vote, the case will be scheduled for October 5th, 2020 at 5 o'clock and will be a public hearing open to written and oral public comments from all parties. Next slide. Okay, so this case was a special exception to establish a short-term rental, extended home rental in the single-family residential R4 zoning district for a property located at 2108 St. James Drive on James Island, TMS number 34302000075. It was approved with conditions on July 20th, 2020. And this request is from Kimberly Glaus and Stephen Dalton for the BZA to reconsider this case at the next available BZA public hearing. Their letters were sent to the board members on July 24th, 2020. On July 20th, it was a unanimous vote, 8-0, and we did have one board member absent, that was Ms. Lechner. And for this case, we have the requester, Ms. Glaus, signed up to speak. And then the property owner, Mr. Vernon, is signed up to speak. He also submitted a letter, and those are the letters that you received on Friday. And then Keely Porter, she also submitted a letter in support of the reconsideration. And she's at 2142 St. James Drive. She did not sign up to speak, but we're going to stick with the requester and the property owner.
Is Ms. Claus available? Is she on?
Yes, would you like to hear from her now?
Yes, we can.
Okay, so I will be promoting her from an attendee to a panelist. Let's go find her name. Let's see.
Jenny, has she been sworn in?
I'm going to do that too.
Okay.
Mrs. Gloss, can you hear us? Or can you, can't find her. Let's see.
I'm here. Can you hear me now?
Oh, yes, we can hear you. Okay, if you can please raise your right hand and repeat after me. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth, I do.
I swear to tell the truth and nothing but the truth. I do.
Thank you. And if you could just state your name and your full name and your address for the record.
Yes, ma'am. My full name is Kimberly Michelle Gloss. My address is 2112 St. James Drive. Of the 7 letters written in opposition to the short-term rental, a few of the more important points made include the following. Number 1, the neighborhood is becoming overwhelmed by short-term rentals. Number 2, many neighbors, including the 2 adjacent neighbors and the neighbor immediately across the street, have expressed that they do not want to live next to a business. Number 3, we can assuredly call this a business as the owner has 8 separate short-term rental listing advised online. Number 4, neighbors have witnessed drug and police activity on multiple occasions. Number 5, neighbors simply don't want to live next to or near a short-term rental. On July 20th, the board made the determination that none of these concerns are weighted heavily enough to determine that the short-term rental would not meet the criterion that it would, quote, not adversely affect the general welfare or character of the immediate community. All of us who wrote in, and I have spoken with every person in opposition, of which there are many who didn't write in, cannot for the life of us understand why this level of concern and opposition would not disqualify this short-term rental under the referenced criterion. Furthermore, Ms. Working stated in the finding of facts from the July 20th meeting that there is adequate off-street parking for up to 6 vehicles, that there exists mature landscaping between the applicants and my property, and that the listing is designed to target families from Charleston. The facts are that a significant portion of the parking is situated across the eastern neighbor's property line. The mature landscaping is overgrown weeds that we are forced to let grow to achieve privacy from complete strangers. And the reviews from his Airbnb profile include guests in order from Rock Hill, Philadelphia, Charlotte, Miami, Inman, Asheville, Columbus, Ohio, Charlotte again, Monroe, Connecticut, Las Vegas, Sacramento, Miami again, Jersey City, Lincolnshire, Illinois, Beaufort, Henderson, Nevada, Jacksonville, Jackson, Wyoming, Costa Mesa, California, Bellingham, Washington, Houston, Myrtle Beach, Sylvania, Ohio, Atlanta, Washington, D.C., and Lehigh, Utah. I don't recall hearing myself mention Charleston in that list. David Vernon sent us a letter months ago demanding that we treat him as a neighbor. The neighbors who lived there previous to the applicant were our friends who we knew well and trusted. It's hard to treat David as a neighbor if he isn't actually our neighbor. He simply owns the piece of property next to us. Thank you.
Thank you, Ms. Claus. We thank you for the information that you submitted today. Does anyone have any questions of Ms. Claus? I see Mr. Goldstein has his hand up. Mr. Goldstein, we can't hear you. Your mic is muted, sir.
Okay, how about now?
We can hear you now, sir.
I have a question of counsel. Of Mr. UG.
Yes.
Mr. UG, if we grant a motion for reconsideration, does that operate as a stay on the applicant's ability to get his permit?
I believe he has his permit. I believe it's already been issued, so I do not believe it will act as a stay. Can you hear me?
Okay. Thank you, sir.
You're welcome.
Does anyone else have a question of Ms. Claus? I see no hands. Okay. Thank you.
Yeah, Ms. Claus, I'm gonna
Thank you,
mute.
Ms. Claus.
I'm gonna mute you and just stay on in case they have more questions for you later. Okay.
Okay, thank you.
I'm gonna mute you.
Ms. Workin, do we have somebody else that you said that needs to speak?
Yes.
Mr. Vernon or
Yes. So I'm gonna promote David Vernon to a panelist. There he is.
Good afternoon. Can you hear me?
Yes.
Yes, we can.
Yes.
Let me swear you in real quick. Raise your right hand. I will say the oath and you will say, I do. I swear to tell the truth and nothing but the truth. I do.
I swear to tell the truth and nothing but the truth. I do.
Thank you.
Mr. Vernon, if you would tell us why you're here tonight and tell us why we should give this case reconsideration.
Well, I'm asking that you don't give this case reconsideration. I think that you guys, you guys made were given all the facts that I have to present in the previous meeting back in July, and at that time you ruled in favor of the exemption of the short-term rental permit. So to clarify, I'm not asking this be reconsidered. Again, I don't want to get back into everything that I presented to this board. The last time that I was in front of it, I felt that I made my case at that time, and the board felt the same as well at the time. But just to comment on a couple things from Ms. Gloss, first and foremost, as I've always said, my intent has never been to any of my actions to in any way hinder the peaceful enjoyment of my neighbors or anybody in the area. As I outlined previously, I've taken many steps to ensure that doesn't happen, from the vetting process that I use to the surveillance equipment, noise monitoring equipment that I use. As I stated before, I feel I go above and beyond what the county asks of a short-term rental host to ensure that nobody is ill affected. I would like to point out that there's outside of one instance that she's commenting that cops were involved, which was very short and was taken care of in a very short time, and I addressed them after that, or not Kimberly, but her husband rather, just to ensure that I made contact with them and that it had been handled. But there's no hardship has been shown as a result of me operating a short-term rental at times at this property. I feel that I've shown that I meet all the criteria, the approval criteria for this exemption. And there's just a handful of things there that are just simply false. I mean, I target families and never claim that I target Charleston families. That's not the case. I do target families. It is a family neighborhood. And that's one of the things that I do when vetting, potential guests is not just I don't ensure that their families necessarily, but ensure that their intent of visiting is not a bachelor party or something of that nature. I hate that she feels the way they do, but the reality of it is I'm taking all the steps necessary and again, going above and beyond, making sure that I don't in any way encroach on their peaceful enjoyment of their property. I've introduced myself to Miss Gloss. I've had a beer with her husband and chatted with him several times. They have my contact information. They know they can come to me if there's ever any issues, in one instance they have, and I appreciate that. But I hate that you can't call me a neighbor, but I don't think that's by any of my doing. I do think it's ironic that you're so opposed to this short-term rental being beside you when you operated a short-term rental in the same neighborhood. You and I both know that. I believe you sold that property in June. Correct me if I'm wrong, but that was what your husband had told me when I originally told him that I intended to rent this property on a short-term basis shortly after I purchased it, and had a conversation with him, and he gave me that information. So that's just a little bit frustrating that it seems a little bit hypocritical to me. But nonetheless, I have and will continue to follow all the rules of this ordinance, and I will continue to do everything that I can to make sure that in no way do I hinder your peaceful enjoyment of your property or any of my neighbors. I'm always available. You have my contact information, and that's all I can really do is just tell you, despite your feelings on this, I will continue to ensure that I do not hinder your peaceful enjoyment of your property.
Okay, that was about 5 minutes.
Thank you, Mr. Vernon.
Yeah.
Yep. Okay. Does any board member have any questions of Mr. Vernon? Mr. Boykin.
Thank you. Good evening, Mr. Vernon. How are you?
Doing well. Yourself?
Doing fine. I'm going to take you back to our prior hearing. I believe I asked you, was this your primary residence? And you indicated yes. Is that still your answer tonight?
Yes, it is.
Do you currently have a South Carolina driver's license?
Yes, I do.
What address do you have on your driver's license?
2108 St. James Drive, Charleston, South Carolina. I have it right here in front of you. If you'd like to see it.
I'm sorry. Are you currently registered to vote in Charleston County?
Yes.
And what address is tied to your voter registration?
I believe that same address is 2108 St. James.
Very well, very well. I know there's a question about how many nights you do or don't spend at this residence. You do have another residence also on James Island, is that correct?
Yes, sir, I do.
Okay. Is there any estimation of what % of your nightly stays you split between these two places?
I stay the majority of the nights I stay in this property at St. James.
Okay, I have no further questions. Thank you.
Thank you, Mr. Boykin. I thought I also saw Mr. Goldstein's hand.
Question
Yes,
for Mr. UG.
Yes,
Can I
sir.
go ahead?
Yes.
Mr. UG, it seems like we're discussing the merits of reconsideration. Are we supposed to be weighing the merits, or is our decision solely whether we're going to allow the protesters an opportunity to come back before the board and make their case?
Well, your decisions is just whether or not to allow them to come back.
That's what I thought. Okay.
Whether you can listen to whatever information you want and give it whatever you want.
Thank you. That answers my question.
Okay.
Does anybody else have any questions? Okay.
Ask a question of staff.
You Mr. Nelson, you have a question for staff?
Yeah, I have a question for staff. And just to refresh my memory on this particular case, Mr. Dalton already qualifies for 72 days, and the request that we allowed was to extend it up to 144 days.
Correct.
Okay.
Yes, sir, that's correct.
All right. Thank you.
Okay. Anyone else has any questions of staff or the applicant? All right. Well, with that being said, I'll close it for public information, and I'll ask for a motion rather to have it for reconsideration. Mr. Boykin.
I'll make a motion that we deny the reconsideration of this case.
Okay, we have a motion on the floor. Do we have a second?
We have a second.
Mr. McConnell. Thank you, sir. So we have a motion and we have a second. Any questions? Mr. Goldstein.
Yes, I appreciate the motion. I'm glad there's a second because I'm glad we have an opportunity to discuss it. I did not hear anything tonight that really made me think that we made a mistake. But on the other hand, I believe strongly that everybody should be given an opportunity to be heard completely and fully. And so the motion tonight is not deciding the merits of whether we erred or not. And I just think that as a service to the citizens of Charleston County, every citizen ought to be afforded every opportunity to state his or her case. And so for that reason, I cannot support the motion. I would vote to allow the protesters to be heard on the merits.
Thank you, Mr. Goldstein. Since we have a motion on the floor, we're going to bring it to a vote. All those in favor to uphold, to deny reconsideration, please raise your right hand and say aye.
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 Aye. 1, 2. All those in opposition, please do likewise.
Nay.
I see two, Mr. Goldstein and Mr. Nelson. So the ayes have it. Thank you. Thank you all. So that is the old business for the first case. Ms. Working, can you give us the information for the second old business? Well, before I go, thank you. Mr. Vernon, within 10 days, the staff will send you information pertaining to your case via certified mail, and you'll be getting that information within that specified time.
We won't be doing that, Mr. Ray. He's already got that.
Right. He's already got that. That's correct. Thank you for that reminder. Just have it, I guess. Thank you. Ms. Working, can you give us the information for the second old business? That's case BZA 04-20-00397.
Yes. Okay, so this is old business item number 2. Request to reconsider BZA 04-20-00397. And I'm gonna move some of this stuff away. As previously stated in number 20 in your rules of procedure, upon vote of the BZA, a member from the prevailing side may make a motion to reconsider a case at the same or next BZA meeting. Any member may second the motion. If the motion to reconsider the case is granted, then the case will be scheduled and heard by the BZA at the same or next BZA public hearing, provided all required notifications have been met. A case may be reconsidered only once. Public comment is at the board's discretion. There is generally no public comment for motion for reconsideration unless the board requests public comment. If a motion to reconsider is not made, the BZA's decision stands and the party may appeal the BZA's decision to circuit court. Final decision and orders for the July 20th cases were mailed on July 31st. Any person with a substantial interest may appeal the BZA's decision to circuit court of Charleston County within 30 calendar days after the decision of the BZA is mailed. If a motion to reconsider is made and passes by majority vote, the case will be scheduled for October 5th, 2020 at 5 o'clock and will be a public hearing open to written and oral public comments from all parties. Next slide. So this case was a variance request to allow an existing gravel and sand shell driveway to remain within the required 35-foot OCRM critical line buffer at 6539, 6543, 6555, and 6569 Maybank Highway on Walmala Island. TMS number 15100000095. It was approved on July 20th, 2020. This request is from Pam and Kelly Skinner and Victoria Fowler for the BZA to reconsider this case at the next available public hearing. Their letters were sent to you on July 31st, 2020. The July 20th vote was 7-1. Miss Allison voted against the motion and Miss Lechner was not present. So on the line today, we have Mr. and Mrs. Skinner, and we also have Victoria Fowler. They're the requesters. One other person signed up to speak. She's not a requester. Her name is Tatiana Polkett. She also sent a letter that did not meet the deadline. So we can talk about that after, I guess, the other speakers get an opportunity to talk. And Miss Bolt is online too as well. So I guess, do you guys want me to start with Pam Skinner?
That would be good.
Okay.
Yes, please. Could you swear her in?
I gotta get her on first. It's a two-step process. All right, I'm promoting her to panelist. And
Promoted to panelist. Yeah, indeed.
all right, Miss Skinner, can you hear me?
Yes.
Okay. Can you please raise your right hand? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
And then just state your name and address for the record.
Okay. My name is Pam Skinner and I live at 1437 Fairview Plantation Road on Wadmalaw Island. And I filed this letter to reconsider for the driveway and the critical line buffer because I honestly feel that the BZA members did not do enough probing or due diligence on this driveway. It seemed that, and I have a letter in here stating all of the issues that we have with this unconditional approval. But according to let me get my letters up here. There was a lot of debate time and we only had the 2 minutes to discuss whether or not a variance was needed. And we felt that it was because according to the zoning variance 9.7 for wetlands, waterways, and the critical line buffer, it specifically states that parking or driveway areas and all saltwater are protected from the driveway, and the purpose of this buffer is to provide a visual, spatial, and ecological transition zone between development and the county's saltwater wetlands. This road, and I have been out to the property next door, and there is and was a grassy road on this property at the time the applicants purchased the property, and it remains that way on the property next door. Has been increased, even though there are not short-term rentals on this property anymore, there are monthly rentals with people coming and going. There are lights going back onto the adjusting properties. This property has ROs, I'm not sure what kind of gravel, but the gravel at the next high tide with full moon tide that we have, there is the possibility of flooding and this washing into pristine Fickling Creek. There are delivery vehicles out there daily dropping off meals for people. monthly rentals, and all 4 units are out there in and out of the property. So I do feel that the criteria were not met. And I feel like there were some questions that weren't answered by the applicant. It just brushed over as to how much rehabilitation was done on the road. And I can show you pictures, if you agree to rehear this case, that shows you what the road that on the adjacent property that came across looked like when it was purchased in the 2019 imagery versus what it looks like now. And it is shocking. And that was why I was very disappointed that the BZA did not ask enough probing questions on this before granting this, and granted it with a open variance and approval with no conditions. And there's traffic now with cars leaking. They could be leaking antifreeze, oil. There are customers, guests, suppliers, cleaning people, maintenance vehicles. Everything is now coming on that road, which used to be a hunting road.
Thank you, Ms. Skinner. We appreciate your testimony today. Do we have any board members that have any questions for Ms. Skinner? I see none. Thank you, Ms. Skinner, for your testimony tonight.
You're welcome.
And
Ms. Workins?
is Mr. Skinner going to speak? Ms. Skinner?
Yes.
He would like to speak, okay. I will promote him, so.
Can you hear me okay?
Yes.
Yes, sir, we can.
Can you please raise your right hand and repeat after me? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I swear to tell the truth and nothing but the truth. I do.
Thank you. And state your name and address for the record.
Kelly Skinner, 1437 Fairview Plantation Road, Wadmalaw Island.
Mrs. Skinner, please tell us or give us your testimony tonight, please, sir.
I think Pam actually covered all the salient points. I really just want to stress and reinforce that, again, the unconditional approval of this endangers the OCRM. And I think at no point really, other than Ms. Allison bringing that up during the discussion, did that pertinent point get realized, that you are actually working within and approving unprotected encroachment to the OCRM line. And as Pam said, you're opening that up to a number of different risks and transient guests that are coming through, because reality is, regardless of how we got there, this is in fact being used as a commercial property right now. So that creates risks that were never intended and the unintended consequences. We do feel that there was a lot of discussion and focus on the lists around 972 and what's allowed. And what's really important, I think, is also looking not at just what's allowed, but what you're going to do with that once you've allowed it. So again, as pointed out, you've allowed the road, and now you've allowed that transient traffic to come in and out and create that risks. Also want to reinforce the point that members asked the question and said, can you go further in and tell us the rehabilitation and how significant and material that was done? And from there, that got pushed aside, and you never got the answers that I think you truly deserve to be able to make a decision. Because I think that not only are you there to protect the zoning and the communities associated to it, you're also there to uphold the protections to the overall OCRM as well. And that's my statement.
Thank you, Mr. Skinner. We do appreciate it.
And the other thing is, elements of hardship that I'm understood were not tested and they were not met. And it would be good for you all to understand and hear how any kind of hardship tests were being met and what are the overall impact of having to make any kind of conditions or changes to it.
Once again, thank you, Mr. Skinner.
Thank you.
Yes, sir. Does anyone have any questions of Mr. Skinner? I see none. Thank you. Ms. Workin, do we have anyone else?
Yes, Victoria Fowler. And hold on, I gotta mute him, and this takes a little second to get this.
Take your time.
Okay, he muted himself. Okay, I promoted Victoria Fowler. Can you hear us?
Can you hear me?
Yes, we can hear you now.
Perfect.
Okay, if you can please raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth, I do.
I swear to tell the truth and nothing but the truth, I do.
Thank you, and just say your full name and address for the record.
My name is Victoria Townsend Fowler, and I have a home at 2539 Grace Chapel Road, Guatemala Island. Well, it's in Rockville, Guatemala Island.
Ms. Fowler, please tell us why you're here tonight and tell us why we should reconsider or not this case.
Yes, thank you for, first of all, hearing the request for reconsideration. I watched from home on the live stream because due to COVID, I felt that the less audience, the better. But during the whole proceedings, Ms. Allison brought up a good point about the site plan and moving that portion of the driveway, which led me to wonder if they deviated from the site plan, how, did we end up here today, or back in July, how did the board end up there today hearing the variance? There was a FOIA request done, and materials show from that FOIA request that there were many iterations of the site plan between the applicant and the county, and the final site plan was approved based on an application that the site plan review application that the applicant stated that this property and these structures were for personal use and not for rent. And I feel that that totally changes the use of the road and would be something that would be good to consider. So my question was, is there more to this story? And should the applicants have requested this variance, or if they decided they did not need a variance, appealed the site plan directors or the planning director's administrative decision at the time? But this all occurred in 2017. So this property has now been improved so much over the past 3 years that we're now in a situation where it makes it a lot harder for the board to really establish and make a good decision, because improvements have been made to this road that really work in the applicant's favor. So based on that, I don't feel that the criteria were met from the applicant's own doing and not of the applicant's cause. And I really feel like this case really should be reconsidered. And that's basically my case in a nutshell.
Okay, thank you. Does any board members have any questions of Ms. Fowler? I see no hands and I hear nothing. Thank you, Ms. Fowler. Ms. Workin, I believe that concludes everybody that's on the slate for
Yes, so
speaking to this.
Mr. Gaskins is on the line. And then we had a third request, but from Tatiana Polkitz. She's not one of the requesters, however, but she requested at minimum that you would accept her letter. Your rules, number 15, state at the public hearing, the BZA may make a motion to accept and consider written material submitted during live witness testimony, either in support or opposition. If the motion passes, all new evidence shall be entered into the official records, and that the party must be prepared to answer BZA questions concerning the material. So again, she's requesting to speak, but she's also requesting that you accept her letter that was submitted after the deadline.
Board, we have information that was submitted here at the last minute. I need a motion to accept or reject this last minute information. Mr. Goldstein.
Make a motion that we accept the late filing and give it due consideration.
Second.
All right, we have a motion that has been moved in second by Ms. Allison. Let's bring it to the vote. All those in favor, please indicate by saying aye and raising your right hand.
Aye.
Okay, so any in opposition, that would be me. So the vote passed to allow this new testimony, this new information that we have here to be presented. Ms. Workin?
Okay. Are you wanting me to read the letter, or did you want her to speak?
I think it'd be easier if she spoke.
Okay. All right, let's get her. I just promoted her to panelist. Can you hear us?
Yes.
Okay. If you can please raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth, I do.
I swear to tell the truth and nothing but the truth, I do.
Okay. And then just state your name, your full name and your address for the record.
Certainly. My name is Tatiana Klemenko Thomas, and our address is 6543 Guatemala Island, South Carolina.
Thank you so very much for swearing in and coming before this august body. Please tell us why you were here tonight.
Yes, sir. I was late by an hour and 30 minutes in submitting my letter. I was not aware of the 12 noon Friday deadline. I assumed it was at 5 o'clock. So I emailed to Ms. Working, and I asked her, please, if my letter can be still accepted, which she advised me that the rule number 15 might apply in my case. And I would like to reiterate that we oppose the approved variance for the many reasons which were stated in 3 of today's testimonies. And my main request to speak was just to make sure that our opposition vote would be added and our letter would be added to the opposition file.
Okay. No, that's it?
That's it. We are very much opposed. We live diagonally across the street, the Pickling Creek from the bolts, and the creek is pristine. We take pride, and we have protected wildlife. And to begin with, as we all know, the whole case was built on the false pretenses that it was to be used for a family and family use only, which is not the case. It became a business. It is a business. And in a nutshell, we oppose the variance because it can jeopardize the pristine wildlife and have unforeseen consequences on many levels.
Okay. Do you have anything else? That'll be it?
That would be it. The main thing is just to have my opposition vote added to existing opposition votes because I was late in submitting our letter. Yes.
Well, we thank you so very much for your testimony tonight. Do we have any questions for her, please? Anyone? Any board member? Okay. I see none and hear none. Thank you so very much for your testimony tonight. Ms. Workin, you said we have one other person?
Mr. Gaskins is on the line, so I'm going to promote him to panelist.
Thank you.
I'm sorry, I was muted. This is Brandon Gaskins. Can y'all hear me now?
Yes. Can you please raise your right hand? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth, I do.
I do.
Okay, and then state your name and address for the record.
Brandon Gaskins, 78 Wentworth Street, Charleston, South Carolina, 29401. And I am the attorney representing the initial applicants, Bulk Tree Farm, LLC. We would request that you deny the, I'm sorry, I'm getting some feedback. Can y'all hear me okay?
Yes, we can.
That you deny the request for reconsideration. If you recall, when we met a month or so ago, there was considerable debate about whether a variance was even needed because the existing road was not in violation of the applicable ordinance because it was not made of impervious material. And based on the discussion that followed, there seemed to be general agreement regarding that principle, and I believe that the motion was made to that effect, but ultimately doing so would create issues with the original site plan and how we would deal with that, which would create some administrative obstacles. So I believe the board decided to grant the variance because that would be easier from an administrative perspective. And so we continue to take that position, believe it's correct. There's been no testimony or evidence to indicate that those grounds do not remain here today because the road is what it is, and it is made of pervious material. So therefore there is no violation of the ordinance and no variance is needed. However, I will address the environmental concerns that have been raised by the neighbors, and will say that those are entirely speculative. There is no evidence that maintaining this road where it is will cause any environmental harm. In fact, I would suggest it's quite the opposite. We have a road that has existed there for 20 years. And if there was evidence that that road was harming the environment, that evidence would be before you. It is not. And so for those reasons, we would request that you deny the request for reconsideration.
Thank you, sir. Do we have anyone on the board that would like to ask Mr. Gaskins a question? Mr. Goldstein, I recognize you.
Thank you, sir. Mr. Gaskins, you agree that the motion on the floor is whether or not we should take another look at our decision, not a decision on the merits, just simply whether or not the protesters should have a right to be heard. That's the only issue before us right now. You understand that?
I do understand that. And what I would say to that is, I think twofold. Is one, I don't think these individuals who have requested reconsideration really have standing to request it. The statute talks about who may appeal, and that's somebody with a substantial interest. I understand that these individuals live on Wadmalaw Island, but they are not, they do not live on adjacent or adjoining property. It's my understanding that they live miles apart. So I don't know if they have standing, but be that as it may, I understand the board can move, can consider matters on its own volition. And if somebody who voted in favor of the variance changes their mind, I certainly understand that. But what I would say is that—
Well, let me interrupt you right there. A vote for reconsideration is not a suggestion that anyone has changed his or her mind. It's simply a vote to give somebody an opportunity to be heard, nothing more, right?
That is correct. And I guess my response would be is that the individuals requesting reconsideration have had an opportunity to be heard. They've had an opportunity to present these issues. They have not presented anything that I think is substantially different than the points that were raised before. So I think all the arguments that you've heard today were considered at the last meeting. But I certainly understand the procedural posture of it. We would rather avoid having to come before you again, though.
Well, sure, absolutely. Now that I understand, but on the other hand, I'm never comfortable with telling someone, no, we made up our mind, we're not going to even, it just sounds too much like I'm infallible. And I guarantee you I can give you my wife's number. She'll tell you that's not true. So I don't know if I ever have any opposition or heartburn about taking a second look at something. And that's the issue before us, is whether or not we want to take a second look at it or not. Not a decision that anybody is right or anybody's wrong. A motion for reconsideration is not asking for decision on the merits, just it's asking for permission to be heard.
I certainly understand that, and I guess my position would be is that to get reconsideration, that those requesting it present some compelling reason to do so, or some new evidence that wasn't considered, and I don't think that they have met that burden.
Okay, well now that's an interesting point. So your view is for us to grant reconsideration, somebody has to say something pointing out to us something we overlooked or failed to consider or gave undue weight to. Is that a fair summary?
I think from a practical perspective, that is correct. I don't know if that's a legal standard that would apply to the Board of Zoning Appeals. I don't think it's necessarily the same standard that would apply in circuit court, but I think generally, as a practical matter, I believe that would be a good operating procedure. Not that I'm one to tell you what your procedure should be, but it can result in a lot of duplication and a waste of time if there are not compelling reasons to revisit a decision.
Okay, thank you, sir.
Do we have anyone else that has any questions for Mr. Gaskins? Thank you so very much, Mr. Gaskins, for your testimony tonight.
Thank you.
Do the Bolts,
Yes.
Would the Bolts like to speak? I'm not sure if they're on.
No, they have requested that I speak on their behalf.
Okay, just want to make sure. And just for the record, we did receive 36 letters. So you guys got those on Friday.
Mm-hmm.
Okay.
All right. Good. We don't have any more people to speak tonight, Ms. Working?
No.
On this particular case? That's it?
That's it.
Okay. So at this time, I'll ask for a motion either to deny or to take a second look at this. Do we have any board member that'd like to make a motion regarding this old business?
I'll take a stab at it.
Mr. Goldstein, the chair recognizes you, sir.
Thank you, sir. I'll take a stab at it. For the same reasons as I articulated in case number one, I just never see the harm in taking a second look at something and giving everybody an opportunity to be heard. And so for that reason, without making any kind of judgment whatsoever on whether the motion for reconsideration is meritorious or not, I'm going to move that we reconsider the decision and give everybody an opportunity to be heard.
Okay, folks, we have a motion on the floor. Do we have a second?
Second.
All right, Ms. Allison has seconded the motion to grant a second look or reconsideration for this particular case. Okay, with that being said, I'd like to bring it to a vote. All those in favor of bringing this case back up for reconsideration, please raise your right hand and state and say aye.
Aye. Aye.
Aye. So that's 1, 2, 3. All right.
Let me do
All right.
can I do a roll call for this one?
Sure.
Yeah, please.
Okay. So the motion is to reconsider the case. Correct. Yes. Okay. So you're voting yes if you want to reconsider the case. Mr. Ray?
Nay.
Lechner?
Aye.
Allison?
Aye.
Boykin?
Nay.
Freeman? No, muted. Mr. Freeman?
Mr. Freeman, you need to unmute your mic, Mr. Freeman.
Yes.
Is your vote aye or nay?
Aye.
Okay. Goldstein?
Aye.
McConnell?
Aye.
Nelson?
Aye.
And Woodall?
Nay.
Okay. I had to count this. 1,
5-4.
3, 4. Yeah. 1,
So
Fails.
it doesn't pass.
2, 4, 5.
So this vote fails, guys. It doesn't pass. So if I'm not mistaken, it does not get or does it get a chance to be reconsidered?
So wait, so five people voted in favor of the motion to reconsider,
That's correct.
and 4
Against? I
against.
thought it was the opposite.
So that's what I got. 1, 2, 3, 4. So I thought it was simple majority.
Oh, is it?
I think so.
Oh, we better ask Mr. UG then.
Yes, please do.
Mr. Yuji, are you on the line, sir?
Yes, I'm here. I believe it is simple majority. I'm trying to confirm.
Oh,
Let me check. You guys are gonna make me look for my rule book. Yeah, I believe that's correct, Jenny.
Okay. So this will be brought before this board, august body again. At the next time the board will meet, I believe, if I'm not correct, Ms. Working.
That's correct.
We also have one other bit of old business, our third item. And that's case BZA 11-17-00219. Ms. Workin,
Okay.
in regards to contempt of court.
Oh, hold on 1 second. I'm trying to make sure. Let me double check our list. I kept Mr. Gaskins on as a panelist, but he's muted. Okay. So this is old business item number 3, review information to determine whether to certify contempt to circuit court as case BZA 11-17-00219. The full January 8th, 2018 transcript for the case is in your packets. Next, please. This is the site plan review application that was submitted on May 23rd, 2017. In the letter of intent, it states this is for our family's personal and private use. These cottages are not going to be for rent. Next. And this is the full application for the variance. They submitted on November 13th, 2017. Stated, I think that's it. Next, sorry. And in their letter of intent for the variance that they submitted, criteria number 5, they said these structures will be for our personal use. This is the part of the transcript where everyone was sworn in for the meeting. Next. And this is the part of the transcript where Seth Gold under oath spoke about how it was going to be used for personal use only. Next, please. And this is just the order issued by the board January 8th and mailed on January 19th, that it was approved with the 2 conditions. Next, please. This document we received on October 30th, 2019. Staff received a copy of the operating agreement for the Bolt Tree Farm dated April 17th, 2017. So this was before the BZA meeting that was January 2018. This document is from April 2017. And in it, the purpose is listed as a luxury vacation rental. The full copy of this agreement is in your packet. And I think that's it. Go to the next one. And that's it. So we can go to any slide you want, or.
Okay. And we don't have anyone tonight to speak on their behalf.
Mr.
Oh, we
Gaskins
have-
is, yeah, Mr. Gaskins is on. Ms. Skinner signed up. So that's up to y'all if how you want to handle that. But he's here in defense of the votes.
All right, let's give Mr. Gaskins the opportunity to speak.
Okay.
Mr. Gaskins?
I gotta unmute him.
Oh.
Can you all hear me?
Yes.
Yes.
If you can please raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And then your name and address again.
Okay. Brandon Gaskins, 78 Wentworth Street, Charleston, South Carolina, 29401. Attorney on behalf of the applicant, Bolt Tree Farm, LLC, and Victoria Bolt. So to begin, I will acknowledge that the information that was presented by the Bolts during the BZA process was not complete. It did not, they did not disclose the fact that short-term rentals would be offered on the property. However, I do not believe that they submitted any false information to the BZA. What they indicated on their letter of intent and in response to one of the questions is that the property would be used for personal use, and when asked during the meeting, Mr. Bolt explained that it would be used for his. All of that is true, and candidly, they should have disclosed the other uses of the property. The reasons they didn't, you know, I think what we've seen over the past 2 years gives you a good indication of why they didn't. And they're younger folks. They were in a new business venture, and they were receiving advice from a lot of people, and they took that advice. And in many cases, it was not good advice. And I think if they had it to do all over again, they would do a lot of things differently, including what is before you today. But going back to, I guess, the matter that is before you, they were sworn to not provide any false testimony, and I don't believe they did. They could have been more forthcoming, and they have paid the price for that. Over the past, I would say, year and a half, if not more, they have been pilloried in the media and on social media for their mistakes. They have had their religion mocked. They have been called criminals. They basically had their business run into the ground. And I think it's important to remember in determining whether you certify contempt is that when they applied for this variance, short-term rentals were a permissible use. There was no short-term rental ordinance in effect. So in many ways, their answer to that question was immaterial to the issue that was before you today, and should not have affected your decision about whether a variance was appropriate or not. Y'all are well aware of the criteria for whether to grant the variance. The only one there's only one that deals with use, and it provides that it shall not allow a use that is prohibited or extend a non-conforming use. So at that moment in time, what short-term rentals were a permissible use. And so if we base it on I think the letter of the law, is that they were not in contempt of the board. And we believe that the circuit court will so find. But I would also ask that you look at this from a human and equitable standpoint. These folks have gone through a lot over the past 2 years, some of which they have brought upon themselves, and they have acknowledged that, and they admitted to their mistakes, and they have apologized, but the hits keep coming, as you have seen today. And as you saw last time, there is a very vocal contingent out there who will not stop until they run the bolts out of town. We ask that you not give in to that you realize that the bolts have made some mistakes, but it's time to put this matter to rest. They have taken steps to come into compliance, which is why we were here a month or so ago and requested the variance. They tried to foster a more cooperative relationship with the planning staff, and they're trying to move forward, but these things keep getting brought up. So for those reasons, we'd ask that you decline certification of contempt to the circuit court. I'll be happy to answer any questions that y'all may have.
Okay, thank you so very much, Mr. Gaskin. I think the first hand that I saw thus far is Mr. Borkins. At this time, Mr. Borkins, you go ahead and ask your question.
Good evening to you, Mr. Gaskins.
Good evening, Mr. Boykins.
Again, I'll restate what I've said before. You have an unenviable task, and I would always go as far as to say insurmountable. This isn't an issue of a lack of candor or a live omission or a lack of full disclosure. We've got an operating agreement that was being prepared prior to this hearing that it was going to be a vacation resort. They were both well aware of what their intent was. They also, it wasn't like they failed to mention they were going to rent it. They went out of their way to say they weren't going to rent it. They went overboard to try to quell the fear of that community and to appease that board that this was going to be personal use. The evidence is incontrovertible, it's compelling, it's deliberate, knowing, willful, misleading, patently false. We can go down all the adjectives of this. There is no excuse or defense to what they did. They did it in writing and they did it orally. And in the case of Mr. Bolt, it was under oath. There's no question they deceived the board. The board didn't have all the facts and information they were entitled to, and they went a step further and deliberately made false statements in writing and orally to that board. I don't see any judge in this world, if they had a witness in court, it would be an issue of perjury. So I appreciate your advocacy for your clients, but it's not even close on my part. But I appreciate your advocacy.
Thank you, Mr. Borkins. Do we have anyone else that would like to ask a question? Mr. Goldstein.
Could I ask either Mr. UG or Mr. Gaskins, what was the date of adoption of the short-term rental ordinance?
I do not know the exact date, so I don't want to venture to guess what it is, but I believe it was in July of 2018.
Yes, I think it's July 24th, 2018. I think that's right.
Okay, so the operating agreement is dated April 17th, 2017.
Correct.
Okay, so the operating agreement is 1 year before the ordinance.
Correct.
That's all I have. Thank you.
And I'll just say one thing about the operating agreement. It certainly states luxury vacation rental, and as I just acknowledged, that part of their plans when they bought the property was to do short-term rentals. I don't think they envisioned doing it on the scale that they did, but circumstances changed and required a change, of course. But it is a business agreement, and because it's a business, you would state a business purpose. So there really wouldn't be a place to put, making it available for friends and family. So that was their purpose, that was partially their purpose at the time, as well as doing short-term rentals. So again, going back, I don't think what they were stating was false, because that was part of their use, and they have used it in that fashion as well.
Well, to be fair to everybody, to be fair to both sides and to the board and to our lawyer and to you, the purpose of the short-term ordinance statute was county council's effort to bring some clarity to what you could and could not do. And you can go up to 72 nights a year just without anybody's permission. And 72 to 144, you got to get permission, and there's a level of regulations. And then above 144, there's a higher level of regulations. You agree with that? We all agree with that.
Yes.
Okay. Does anyone else have a question for Mr. Boykins?
Gaskins, if I may, isn't it true that the Bolts already had a vacation rental treehouse operating in Walhalla prior to this application to this board?
I don't know the date of when it began operating. I believe that they had set it up. I don't know the dates of operation.
So I guess my point is they were very well familiar with bringing the tree houses up in Walhalla, and again, that underlies their intent, clearly, which the operating agreement established, that they were going to do the same thing down here on Wadmalaw. And the only other thing I would point out is that for this particular contempt of court decision, all the stuff about short-term rental is not applicable or germane. It's about what was said, what was presented to this board on that day. And the question on that day was the encroachment of more than 25% of protected trees. And they, in fact, provided false information, misleading information to the board, and they got the variance approval that they were seeking. And I'm done.
Anyone else? Thank you, Mr. Boykins. And thank you, Mr. Gatson. Ms. Workin, do we have anyone else? Are the Bolts available and would like to?
I think he said he was representing them today. But we did receive 40 letters in support of contempt of court. Oh my gosh, I can't say. So, and like I said, Ms. Skinner did sign up to speak, if you would allow
that. Board, we have a request to allow or not allow Ms. Skinner to speak to us tonight regarding this contempt of court. How does the body feel regarding allowing her the opportunity to speak?
I'll make a motion that she be allowed to speak.
All right. I see another hand go up, Mr. Goldstein. I take it that you second that? Yeah,
since it, no. I first of all, I didn't hear what he said. If you could ask Mr. Boykin to get closer to the microphone, or maybe it's my hearing. I couldn't hear what he said. Could I repeat what he said?
Mr. Goldstein, I was going to make a motion to allow Ms. Skinner to address the board.
Okay, I'll address that if there's a second.
Do we have a second? Mr. Wardall has seconded the motion. I'll bring it to a vote.
Well, I'd like, can we have discussion on it?
Yes.
I don't think it's appropriate to take testimony from outsiders on the issue of contempt of court. I think that's a matter that belongs exclusively to the board. I certainly have no objection to hearing from the defendant, as it is, or what, I don't know what you want to call the target. But contempt of court is between us as the board and the circuit court. I think it would be inappropriate to allow third to weigh in on that. So I'm not going to support the motion.
If I may address
Very good.
council. Question for council.
Can you
Go
all
ahead,
hear?
Mr. Walker.
Mr. UG, what is your opinion as to Ms. Skinner being allowed to speak? I certainly agree with Mr. Goldstein's assessment that it wouldn't be fair to have an adverse party speak and not the person that is going to be part of this adverse process.
Yes. Can you all hear me?
Yes.
Okay. No, I am in agreement, and I was going to speak and say something, but Mr. Goldstein is correct. I think you, at this point, you do not need to bring in, if she presents new evidence, right? That's a problem. So she should not, this is based on evidence that's already been presented to the board. And so you'll make your decision based on what is already there. It would be inappropriate.
My motion.
Thank you.
The motion has been rescinded,
Yes.
and hearing nothing forward, we won't allow to have any other testimony regarding this contempt of court. Ms. Working? Do you have anything?
No. Guess you just need a vote on what you guys want to do.
Okay. All right. Excuse me. Board, at this time, I'd like to get a motion to either uphold our determination stating that the Bolts did give false testimony or not. Mr. Borkin, Mr. Hughes, I need to reword that.
Yes, I think the wording is the board needs to decide whether or not to certify contempt of court based on the previous testimony, including whatever you've heard here today from Attorney Gaskins.
Okay. So once again, the board needs to certify whether the testimony that we heard today is in line with what we have on the table. Mr.
Chair,
Borkin?
I will make a motion that we certify contempt of court against both Tori and Seth Bolt and Bolt Tree Farm LLC as parties to that contempt of court. If that is the proper formation of that, based upon all of the evidence that's presented to us through testimony in writing, the record, the transcript of that hearing, and everything we've heard up to this date.
Second.
Okay, you've heard the motion. Mr. Woodall, did I see a second?
Second.
Okay. So we have a motion that's properly moved and seconded. Do we have a question? Then I'll bring out the vote. All those in favor of the motion that Mr. Borkins made, please raise your right hand and say aye.
Aye.
Aye. I apologize. Ms. Workin, would you call the roll? I think we need to call the roll on this one.
Yeah, and the motion is to certify contempt to court. Mr. Ray,
Yes, that is correct. Oh.
what's your vote?
Sorry. Aye. I thought you were restating it. I apologize.
Lechner,
Aye.
Allison,
Aye.
Boykin,
Aye.
Freeman. I think he might be muted.
Unmute yourself, Mr. Freeman.
Where'd he go? Mr. Freeman, can you unmute?
I think he's frozen.
Oh no, I don't know what to do about that. Okay, so the next would be Goldstein,
Nay.
McConnell,
Aye.
Nelson,
Aye.
and Woodall.
Yay. Aye, excuse me, aye. Aye.
Okay, so that's everyone is in favor of the motion, and we just got to get Mr., but that's definitely a majority.
7-1 so far.
I saw him. Oh, there he goes. Mr. Freeman, did you hear the motion?
Aye.
Okay, okay. Okay, so it's unanimous.
No, 8-1. 8-1.
Who had an A? I'm sorry.
1 nay.
Who was that?
Goldstein.
Goldstein. Okay, I apologize. I wrote that down. Okay, got it.
Thank you. So that passes. Very good. So thank you, board, thus far. That moves us forward out of old business to our new slate of new business, which brings us to case BZ 06-20-0043.
Mr. Ray, if I could interrupt a moment. Mr. Boykin, your mic is very, very, very low. Could you look at it and see if maybe you can turn up the volume a little bit? You're very hard to hear.
That's a 4-3. 403. Thank you.
Let me see if I can find the mute microphone control.
Jenny, while he's doing that, are we skipping over case 402?
Did I?
No.
Yeah.
No, we had to do it in this order.
Okay, that's fine.
Yeah. We're not skipping it, but you're correct. It's out of sequence.
Okay.
We can continue. I just wanted to make sure that Mr. Boykin was aware of that in case this was important for the recording.
Yes. Okay. Mr. Ray, are you on there?
Yes. Yes, we're at 403.
Yes.
Who's presenting this? Oh, I'm sorry. Staff presenting this application would be Mr. Downey.
All right. The applicant and property owner, Mr. Robert No, is requesting a special exception to establish a short-term rental, extended home rental in the low-density manufacturing housing subdivision MHS zoning district at 1614 Wedgen Lane, TMS number 33107000100 on James Island in Charleston County. The subject property and the properties to the north, south, east, and west are all located in the low-density housing subdivision MHS. The property contains an 1896 square foot, 1.5-story house with 4 bedrooms and was constructed in 2004 per Charleston County records. The applicant's letter of intent states we will be renting out 4 bedrooms and allow up to 8 people to stay in the house for up to 144 days a year. Currently, the subject property is in site plan review process ZSPR 0520000473 for the proposed use. The applicant's STR property zoning permit application states that the maximum of 4 bedrooms will be rented and 6 parking spaces will be provided as shown on the proposed site plan. And the property will be non-owner occupied. Staff conducted a site visit on July the 16th, 2020. Please review the attachments for further details. The Board of Zoning Appeals may approve the conditions or deny BZA 06-20-00403 special exception request to establish a short-term rental, extended home rental in the low-density manufacturing housing subdivision MHS zoning district at 1614 Wedgen Lane, TMS number 3310700 on James Island in Charleston County, based on the BZA's fact finding, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following conditions recommended by staff. Number one, prior to the zoning permits approval, the applicant shall complete the site plan review process. Number two, the use shall comply with all requirements of Article 6.8. And number three, the property owner shall be responsible for ensuring that the tenants comply with the Charleston County noise ordinance. This is the staff. The site plan was shown, and also there's the site plan that was shown. You should have in your packets. Next slide. A closer look at the survey. Next slide. And that is the recorded plat, and the blue is the subject property. Any questions for staff?
Okay, if there's no questions, I can at this time promote the applicant. So I'm going to promote Mr. Robert No to a panelist. Mr. No, can you unmute, please? Okay, there you go. Can you hear me? Good? Yes, we hear you. All right. Please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Okay, and then state your full name and your current address for the record.
My name is Robert P. No. My address is 1573 Turns Nest Road, Charleston, South Carolina, 29412. Is that it?
I'm trying to mute Mr. Ray. I think he's trying to talk. Jennifer, can you unmute them? Thank you.
Okay. Thank you, Ms. Stiles. Mr. No, thank you for coming before us tonight. Please tell this board why we should approve your application, sir.
Because there are numerous other houses in the same neighborhood that are short-term rentals. And this is, when I started this process in 2018, there was no short-term rental permit, and I tried to comply with all the laws to do so. I've never hidden the purpose of my application, and I think it should be approved on its merits, and I will follow all the laws applicable.
Okay, thank you, sir. Does anyone have any questions of the applicant? Does anyone have any questions of Mr. No? Thank you so very much, Mr. No, for your time.
Thank you all very much.
Okay, we did not have any speakers sign up in support. We do have one speaker in opposition, Laura Gallagher. Give me a minute. Get her. Okay, so I just appointed her to panelist. Okay, Laura, can you hear me?
I can hear you.
Okay, great. We can hear you. Okay. Can you please raise your right hand? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And then state your
Get up.
full name and address for the record.
Okay. This is Laura Elizabeth Gallagher, and I live at 1610 Widgeon Lane, which is the property right next door to the rental property. And the reason why I'm in opposition is because from the beginning, this property was built as a rental property. And when it was a long-term rental property, then we had families that participated in the neighborhood. We had that quality of life that comes from having good neighbors. We have seen Widgeon Lane change over the years, more families moving in, and we have now children, young children, all the way up to our elderly neighbor who's 90 years old and is out walking his dog all the time. And my concern is that the quality of life changes when you have a short-term rental. So I honestly did not have any problem with long-term rentals and families being here. But when it became a short-term rental, we started having some problems. With my property, that's, I have the fence property next door. So things get thrown over the fence. People have thrown bones to my dogs who do not eat bones. And there's been a couple of problems with noise, the lights blazing at night. There's not really a good line of communication between Mr. Robert and the neighbors, in my opinion. And I think that even during the hurricanes, when we had the long-term renters here, everybody kind of pitched in and worked together. But with a short-term rental, I mean, it's either empty, vacant, or you've got a crowd of people in there. I will say that Mr. Roberts takes very good care of the property. I'm very concerned about switching over to that short-term rental Airbnb kind of mentality, especially in a 4-bedroom house where, being near to the beach community can be a problem when you get a lot of different people packed into that house. And that's my concern.
Thank you, Ms. Gallagher. Please hold on because we may have a board member that has a question for you. Do we have a board member that has a question for you? No? Ms. Gallagher, at this time, I'd like to thank you for coming before this body and speaking.
Thank you. Appreciate the opportunity.
Yes. Okay. Mr. No, you have the right of rebuttal, and you're limited to 2 minutes, sir. He needs to be unmuted, I think.
Can you hear me?
Yes.
Yes, sir.
Yes. Ms. Gallagher's always been a very nice neighbor. However, the only true complaint I heard from her was that the lights were left on and somebody threw a bone to her dog and some very minor things. And she professes to speak for some of the neighbors, but I know that the neighbor who is the elderly man is a little French man that I often speak French with on the street. And his daughter was a former realtor that helped me manage this place. So I doubt she can speak for everyone concerned. And I just hope that y'all realize that her complaints are minor and could happen with any tenant. That's all I have to say.
Thank you, sir. Just hold one moment. Someone might have another question for you. Does anyone on the board have a question for Mr. No? Noel, excuse me. Thank you, sir, for your rebuttal.
Thank you very much.
Yes, sir. Board, at this time, does anyone have any questions, comments, discussion? Very good. Let's bring it to a vote. All those in favor of?
You need a motion.
We need a motion. Good gosh, I'm about to move. You see, I'm ready to go home. I need a motion. Ms. Latner.
Thank you, Mr. Ray. I'd like to make a motion that in case BZA-06-20-00403, that we vote to approve the special exception based on the following criteria for the case. Criteria 1, it is consistent with the recommendations contained in the Charleston County Comprehensive Plan and the character of the underlying zoning district. Criteria 2, it's compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. Criteria 3, adequate provision is made for such items as setbacks, buffering, including fences or landscaping, to protect adjacent properties from possible adverse influence of the proposed use. Criteria 4, will be developed in a way that will preserve and incorporate any important natural features. Criteria 5, it complies with all applicable rules, regulations, laws, and standards of this ordinance. And criteria 6, vehicular traffic and pedestrian movement on adjacent roads shall not be hindered or endangered. And I ask that we include the 3 conditions recommended by staff.
Thank you, Ms. Lechner. Now, at this time, do we have a second?
Second.
All right. Well, we have Mr. McConnell. He made the second. All right. At this time, let's bring it to a vote. All those in favor of approving this application, please indicate by raising your right hand and saying aye.
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 Aye. I think that's unanimous, if I'm not mistaken. Any in opposition? Any nays? So, Ms. Workin, that was unanimous. Thank you. At this time, sir, within 10 days, you will be receiving a certified letter from the planning department letting you know the next step in the process. Congratulations, sir. Okay. Our next case will be case BZA 06-20-00404, and that case will be done by Mr. Edgar Sada.
Thank you, Mr. Ray. The applicant and property owner Ben C. Danson III is requesting a variance to reduce the required 15-foot rear setback by 10.6 feet to 4.4 feet for the proposed addition at 2111 West Rivers Road, TMS number 343-03-00006 on James Island in Charleston County. The subject property is located in the Riverland Terrace subdivision. The subject property and adjacent properties are located in the single-family residential R4 zoning district, Charleston County Zoning and Land Development Regulations, Ordinance Zeldar, Chapter 4, Bay Zoning Districts, Article 4.10, R4, Single-Family Residential 4 District, Section 410.3, Density, Intensity, and Dimensional Standards requires a 15-foot rear setback. The subject property is 0.24 acres and contains a single-family home that was constructed in 1923 per Charleston County records, and a detached accessory building that was constructed in 1950. Prior to 2013, the detached accessory building was a non-conforming detached garage. On October 7th, 2013, Floyd Wark, a previous owner of the property, was granted a variance case BZA 3-16903 for the reduction of the required 5-foot interior side setback from the eastern property line by 4.3 feet to 0.7 feet, and for the reduction of the required 15-foot rear setback by 10.6 feet to 4.4 to attach the existing detached accessory building to the existing principal building to create one principal building. You can see the final decision in order on variance application BZA 9-13-1603. You have that in your packet. The staff conducted a site visit on the subject property on July 6, 2020, and on August 11, 2020. In order to save some time here, I'm just going to address a couple of issues. So the first one is criteria number 6. The need for the variance is not the result of the applicant's own actions. The need for the variance is the result of the applicant's own actions. The applicant began construction on the addition before applying for the zoning and building permits. Therefore, the request does not meet this criteria. Here we have pictures of the additions, the surrounding properties. That's Ridge Road. Variance approval criteria. The criteria that I addressed is criteria 6. In the event the BZA decides to approve the application, staff recommends the following condition. The applicant shall obtain all required zoning and building permits for the proposed renovation and addition. Do I have any question? Or here's a site plan, survey, and plat. If you have any questions, I'll do my best to answer them now. Mr. Ray, you're muted. You're gonna have to unmute. There you go.
Thank you. Thank you, sir, and thank you.
Yes, sir.
Does anyone have any questions of Mr. Sada? Any board member? Okay. Well, at this time, if the applicant is available, we'd like to hear from the applicant.
Okay. Yeah, I'm going to promote Ben Dantzler. And Mr. Dantzler, can you please unmute?
Hello.
Hi, how are you? I'm going to go ahead and swear you in. If you can please raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And just state your full name and address for the record.
Okay. I'm Ben Dantzler, and my current address is 127 Simon Street, Charleston, South Carolina. And my wife and I recently purchased the property on 2111 West Rivers Road in Riverland Terrace, with the intention of moving there and living there with our 10 and 12-year-old boys for the foreseeable future. Currently, we're in 1,100 square feet downtown, and we're looking for more space. And we found an old house in Riverland Terrace. It's a 100-year-old structure, fairly small house. On the back of this lot with the 100-year-old house, there was a mother-in-law suite that was roughly 28 by 18, I believe. And it was fairly run down. It was granted a variance, I believe, in 2013, and to encroach on the left side and the rear property lines. It's fairly run down, like I said. It's become an eyesore, as you can see by the letters that were written by my neighbors, and, you know, in badly need of being redone. The main house is in good shape, but it is a 100-year-old house. And when we moved in, I had conversations with my neighbors across the street and down the street, 3 of which have been there for between 30 and 40 years. And I have recommendations from 2 of them. But the house kind of has some historical value to it, and it's kind of an icon of the neighborhood, and is referred to as the Red Barn House. And, you know, they kind of told me several stories about it. And, you know, in an effort to preserve the historical value and I guess the structural integrity and not open up this 100-year-old house, you know, we prefer to extend the variance, I guess, down the rear property line, not encroaching on any more neighbors than we already are, and, you know, essentially creating an identical structure to what my neighbor to the right has in his yard, basically. We spoke to all of our neighbors on each side and have their complete support. Each one of them wrote a letter. I met with my neighbor behind me, and we went through several options. And in his letter, you can see Henry Weed, he, discussed that we were more concerned with what he thought and his opinion on it moving forward than we were with what we actually did. We looked at different things, and he was in complete support of it and liked the idea. As you can see on the staff report, we meet all of the other criteria. Concerning the one criteria that we don't meet, we did this in April. My wife and I were trying to get over there, get our kids into school before, July, August, and that was at the time when Corona was starting to shut everything down. And we're extremely nervous that it would get held up and we would be several months out, which obviously we are now. But, a hasty decision, wasn't the right one, wasn't trying to pull the wool over anyone's eyes. We, immediately stopped once we were tagged. And like I said, I don't want to open up this 100-year-old house and remodel and change the look of it. I think we did the right thing for the house, the 100-year-old structure. I think we've done the right thing for the neighborhood and its look, as you have several, structures like this in Riverland Terrace. I think we did the right thing for all of our immediate neighbors, as each neighbor, connected to us. All four of them have written a letter of approval, and the right thing for my family. And I'm hoping that, I'm hoping the board agrees. Thank you. And that's all I've got.
Thank you so very much, sir, for your testimony today. We had a problem trying to get me unmuted. Does anyone have a question of the applicant? Does anyone have a question for Mr. Dantzler? Very good. Thank you, Mr. Dantzler, for your testimony today.
Thank you.
Okay. Ms. Workin, we don't have anything in opposition or anyone in opposition?
We have a speaker that would like to speak in support. And only one speaker in support and none in opposition. So.
Okay. Let's bring forth that person, please.
Okay. All right. Mr. Appel, can you unmute?
Yes, ma'am. I've learned my way around Zoom over the past several months.
Okay,
Thank you very much for having me.
You're welcome. Can you please raise your right hand and repeat after me? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thanks.
Thank you, Ms. Working and Chairman and BZA members. It's a pleasure to see everybody this evening. I just wanted to briefly just mention one quick point of law. It has to do with criteria number 6. This is the criteria that was highlighted during staff's report. This is the one that states, quote, "The need for the variance is not the result of the applicant's own action," end quote. I would just point out that this criteria is not in the variance test as it appears in the South Carolina Code of Laws. And I know Commissioner Goldstein and I have talked about this over the years in hearings about whether this is a proper criteria for the board's consideration, given the fact that it doesn't appear in the state law. And I would just like to say for the record that this is not a criteria that's properly considered by the board due to its absence from the state test, which sort of preempts the administration of the BZA, including the variance test and the variance criteria. And also I would point out just that, on some level, the need for a variance is always the result of an applicant's own actions on some level. So I don't want to unnecessarily lawyer this one up. I think Mr. Dantzler made a wonderful presentation. I think that the fact that he's reached out to the neighbors and obtained universal approval speaks for itself, and the fact that we meet all the other criteria is very, very positive and indicative of a very well thought out, well presented request, and we would hope that you would grant this approval this evening. Thanks so much.
Thank you so very much, Ross, for your testimony there. Do we have anyone that has a question of Mr. Appel? Mr. Goldstein's lips are moving, but Mr. Goldstein, do you have a question?
Yeah, I was going to say, since Mr. Appel's under oath, that could take a while.
Huh. You know what they say about lawyers when their lips are moving, right? I'm saying that about myself, not you, Tommy.
Very good, gentlemen. Okay. Is that it, Ms. Working?
Yes, as far as speakers, and I don't think a rebuttal is necessary if there were no opposition.
Correct. All right, guys, we need a motion, either to approve or deny.
I'm happy to do it.
Thank you, Mr. Goldstein.
I'm going to make a motion on case number BZA 0620000404, the application of Ben Dantzler III. Despite what Mr. Appel says, I'm going to make a motion that variance be granted, and I do so based on the following findings of fact: that pursuant to the required statutory factors, there are extraordinary and exceptional conditions pertaining this particular piece of property, particularly because the subdivision was so long ago and the lots are so small. So I think he meets criteria 1. As for criteria 2, the conditions do generally apply to other property in the vicinity because the other lots are similarly situated. However, as Mr. Dantzler pointed out, this is a 100-year-old house, and it is configured in such a way that it really cannot be improved in any way other than the fashion in which he's undertaken. So I think he makes the case for criteria 2. As for criteria 3, because of these conditions, the application of the ordinance would effectively prohibit or unreasonable restrict the utilization, because a strict application would prevent any improvement to the property at all. So he meets criteria 3. As for criteria 4, it clearly will not be a substantial detriment to the surrounding property. In fact, his neighbors have all written in saying it will enhance the value of the property. As for criteria 5, granting the variance would not is not establishing the use that's not otherwise specifically authorized by the ordinance. So he meets criteria 5. As for criteria 6, I understand why Mr. Sada said what he did. However, again, because of the layout of the subdivision and the way that the houses have been configured for many, many years, I do not think that the effort to improve the property is a result of the applicant's own actions. In other words, I don't think he's creating his dilemma. I think he's forced into it by the configuration of the lot. So I think he establishes sufficient evidence to meet criteria 6. For criteria 7, granting the variance does not substantially or even minimally conflict with the comprehensive plan. Now, I was concerned that he started the construction without getting permission, but I guess it's easier to get forgiveness than permission, so he's getting it if my motion carries the day. However, I would adopt and attach the conditions supplied by our staff or recommended by our staff that prior to completing this project, that the applicant will obtain all required zoning and building permits for the proposed renovation and addition. And also, I understand that the old storage building is being removed, and so that's another factor that I failed to recite, but that also goes to the categories that I previously discussed. So for those reasons, I make a motion that the application be granted.
Thank you, Mr. Goldstein. I see Mr. Balkin's hand went up quickly.
I'll second the motion, Mr. Chairman.
Yes. Thank you, sir. All right, we have a motion that's been properly moved in second. I'd like to bring it to a vote. All those in favor please indicate by saying aye and raising your right hand.
Aye.
Aye. Nay? Got the same rights. Hearing none. Motion is closed. And I'd like to congratulate Mr. Dantzler for getting his application approved. Within 10 days, you will get a certified letter from staff telling you exactly what to do in the next part of the process. Congratulations, sir. Does anybody need to take a 2 or 3 minute break?
I'm just going to go lock I'm going to go lock my front door because I'm here by myself.
Okay.
I could use a quick break.
Okay, at this time, if you don't mind, let's take a 5-minute recess and come back at 5 minutes, 7:11. Thank you. All right, I'm seeing a lot of people come back into their screens. So let's proceed, please, ma'am.
Yep.
To record.
Yes.
All right. So the next case we have is case BZA 05-20-00402. And this case will be done once again by Mr. Edgar Sada.
Thank you again, Mr. A. The applicant and property owner, Jessica Herbert, is requesting a variance to reduce the required 25-foot front street side setback along Royston Road and Rifle Range Road for the following existing unpermitted structures: a 12 by 12-foot shed, swimming pool, pool deck and steps and spa, front porch and steps at 1622 Rifle Range Road, TMS number 560000024 in the east area of Charleston County. The subject property and adjacent properties to the north and southwest are located in the single-family residential R4 zoning district. The adjacent properties to the northwest, south, and east are located in the town of Mount Pleasant's jurisdiction. The Charleston County Zoning and Land Development Regulations Ordinance, Seldar, Chapter 4, Base Zoning Districts, Article 4.10 R4, Single-Family Residential 4 Districts. Section 410.3, Density, Intensity, and Dimensional Standards requires a 25-foot front street side setback. Article 4.2, Measurements, Computations, and Exceptions. Section 4.23, Setbacks. F, Setbacks on corner and double frontage lots states, on corner and double frontage lots, front setback standards will apply to each lot line that borders a street. The remaining lot lines will be subject to the side setback standards. There's no rear lot line. The subject property is 0.29 acres and contains a single-family home that was constructed in 1970 per Charleston County records, and a detached accessory building that was constructed in 1981 per Charleston County records. The property, Lot 1, Block C, was created and recorded in 1965, Plat Book T, page 120. The applicant purchased the lot from the Federal Home Loan Mortgage Corporation, January 2012. The unpermitted shed measures 12 by 12 feet and is approximately 18 feet from the property line along Royston Road. Here we see the spa, and here we can see the shed as well. The above ground pool is 18 feet in diameter and 50 inches high, and is located approximately 6 feet from the property line along Rifle Range Road. The deck next to the pool is 44 inches in height with an area of 52 inches by 9 inches. The spa is 7 feet and by 7, and the front porch and steps are located approximately 22 feet from the property line along Rifle Range Road at the closest point. The variance is being requested within BZA case BZA 05-20-0402. May be considered independently for approval with conditions, or disapproval. Staff conducted a site visit on the subject property on July 6, 2020, and on August 12, 2020. Again, to save some time, I'm just going to address criteria number 6. The need for the variance is not the result of the applicant's own actions. The need for the variance is the result of the applicant's own actions because the applicant constructed the shed, located the pool, pool deck and steps, front porch additions and steps, and spa within the 25 front street side setback, and did not apply for zoning or building permits for those said pool and deck and all that. So in the event the BZA decides to approve this application, staff recommends the following condition. The applicant shall obtain all required zoning and building permits for the structures. If there's any questions to the staff, here's the site plan. Plat. I'll do my best to answer them now.
Okay, does anybody have any questions of staff? Very good. Ms. Working, could you bring on the applicant, please?
Yes, I'm going to promote Mrs. Jessica Herbert. Okay, she's unmuted. Jessica, can you hear me?
Yes, I can.
Okay, please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Okay, and just state your full name and address for the record.
Jessica Louise Herbert, 1622 Rifle Range Road, Mount Pleasant, South Carolina.
Thank you, Ms. Herbert, for coming and appearing before us today. Please tell the board why we should approve your application.
I'm asking that you grant a variance for the listed structures on my property. If this is all granted, I plan on obtaining a permit for all the required structures. The first I wanted to address is our pool and the platform next to the pool. The pool's just a soft-sided, inexpensive pool from Walmart, which we usually replace every other year due to just the life expectancy of such a pool. We built a temporary platform structure that's not cemented in the ground, just for easier access of the pool to for our young children and to have a place to sit and watch them when they swim. We do have space in our backyard. However, then the way the neighborhood is situated, there's a fence along Royston that the HOA put up with a driveway access that looks directly into our backyard. And so we decided to place it in the front yard. We actually had a neighbor after reading the ordinance or after reading the letter that was sent out, asked us if we were getting a pool. So it's not visible. It's in a secluded spot. In terms of the spa, I wanted to address the front deck in the spa. I was unaware that we needed a permit for a hot tub or a spa and am willing to do so. However, if we had to move it, it would be significant expense to us to move it into another location. It is only 3 feet too close, or 2.5 feet too close to the 25-foot setback. So I'm asking for a variance on this. We also have a 6-foot extension on our deck, which is 3 feet too close to that 25-foot setback. So I'm just asking for a variance on this 3 feet. That deck was built to cover up an existing cement porch that was pretty dilapidated. The last issue is the shed. The shed is 7 feet too close to the property line. As you can see from the photos, it's barely visible from either road. And it only adds aesthetically to our house. Our house was pretty run down when we purchased it. So we were just trying to clean it up and make some storage that was accessible via our driveway. We actually park off of the Royston side of the street for convenience and safety going in and out of rifle range. I'd like to apologize for not applying for permits initially. The only excuse I have is ignorance and bad advice, really, and not knowing what did and did not need a permit. If the board approves the variances I'm asking for, I would be happy to go through the zoning and the permitting process. And that's all I have to say.
Thank you, Ms. Herbert. We appreciate your testimony. Please hold tight. Let us find out if we have any board members that would like to ask you a question. Do we have a board member that would like to ask a question of the applicant? Nobody east of the Cooper want to ask a question. Okay. Very good. Ms. Herbert, thank you for your testimony today. Ms. Workin, do we have anyone else slated to speak in favor of this application?
No, we don't have anyone in favor or in opposition.
All right. Well, board, do we have any questions, any discussion?
Can I go back to oh, sorry.
Go ahead.
Yes, Mr.
Can I go back to Mr. Sada for a minute?
Yes, sir.
Yes.
I am confused by the pool. Why do they need a permit for the pool? It's just a plastic pool.
It's in the setback, and if it's over a certain, I think if it's over 2 feet deep, you need a permit for that. So that's why they need a permit.
And they need a building permit for it too. For that in the spa.
For a plastic pool from Walmart?
It's deeper than 2 feet.
Say again? Say
If
again?
it's deeper than 2 feet.
Oh, good grief.
Yeah, you know what? I didn't mention that there is space. There's space in the backyard for it. So, I mean, I can see her concern that people can look in there, but there is space where she could put that pool. And like she said, you know, she buys a pool every, you know, every 2 years. So,
so if it's 24 inches deep, she doesn't need a permit.
I think that's correct, but you're still in the setback.
Okay. Well,
you can't have anything permanent in the setback.
Well, it's not permanent. It's just a plastic pool.
Right, but if it's permanent, if you keep buying it or keep replacing it and keep putting it at the same spot, it's permanent. I mean, you're keeping it there.
And all the mechanical equipment as well.
Well, what about a bird bath? Would that require a permit?
I don't think so.
Less than 2 feet deep, Mr. Goldstein.
True.
Thank you, Mr. Goldstein, for that very, very nice line of questioning. Thank you. Do we have a motion on the floor that we can present? Anybody like to make a motion? About the
I should have asked the applicant. Can I ask a question first? I probably should have asked the applicant this, but Mr. Sada, you might be able to answer.
I can unmute her too if you want. So,
if necessary, but just the way the lot is configured, the front of this house really along Rifle Range Road appears to essentially be the back of the house at this point. So, are we kind of getting into a little issue like that with the way the big privacy fence exists along Rifle Range Road?
The privacy fence exists along both Rifle Range and Royston Road. There's an opening for a driveway off of Royston Road, but the front of the house is facing Rifle Range Road.
But there's no openings in the privacy
front of the
fence.
house. The front is facing Rifle Range Road.
Got it.
We can go back and see that real quick so you guys can see it in the pictures. So real quick, here's a site plan, right? This is the main house. Well, it's the house, and where the front porch is at, that's the front of it. That's the front of the house, right?
Right.
Let's see, that's Rifle Range Road. Here's Royston. It's still privacy fence, right? It's not as high as the other one, but there is a privacy fence, and I want to say that that's facing the opposite side.
Yes.
And alongside where you see the 17 speed limit at 17 miles per hour, that's their privacy fence. Let's go back and see the actual subject property. And this is the front of the house. That's facing Rifle Range Road.
Right, but that big privacy fence on the photo on the left, there are no openings on the Rifle Range Road right there, correct?
No, there isn't. I mean, there's a side fence, like a side door fence that you can get into from this property. There is a driveway off Rifle Range Road. I'm not sure if there's a picture of it here. There it is.
Yeah, that's it.
This is a small driveway off Rifle Range Road.
Okay.
There is, I mean, I think she's trying to get an ADU in the back area. It's different from this case, right? But I think that possibly people could park there for that ADU. So there is a driveway there.
Okay.
Right.
That large privacy fence, does that belong to the homeowner or to the neighborhood? The large one?
The large brown one, let's ask
right.
her. I think it belongs to her, but I mean, I think maybe I'm not sure. Can we ask that question to her?
Jessica?
Yes, yeah. The wood, large, taller fence, that is our fence. If you wouldn't mind going back to the white fence picture, just so I can explain. That picture in the, that picture in the upper left-hand corner, that's looking out of our technically backyard behind the house. You're looking at our neighbor's house though. So we have a 6-foot fence with a large opening in it that actually looks right into our backyard. The brown fence behind the white fence, our neighbors put up on their property to give them some additional privacy. So they put up an additional fence, but the white fence, that is a neighborhood association. There's an HOA behind us. That is their fence. And when I actually applied, I'm going through the process of converting our back shed to an ADU. We have our in-laws come stay there often, and family and friends. I was given the choice of converting our house to a Royston Road address. So it kind of is the case where we really come in off of Royston. Our front yard, which is on Rifle Range, is more like our backyard at this point.
And that's where the pool is?
Yes.
Okay.
All righty. Thank you, Ms. Herbert. Thank you. Thank you all. All right. Any more questions? All right, ladies and gentlemen. We want to close this to public. And I need a motion, please.
I'll make a motion.
Thank you.
In the matter of BZA 05200042, I'll motion that we approve the variance. One, there do appear to be extraordinary and exceptional conditions pertaining to this particular piece of property, particularly in relation to its proximity to Rifle Range Road and how the house has been configured since that time, and access off of Royston Road. Two, the conditions do not generally apply to other properties in the vicinity. I don't believe other properties right along that stretch, have the double frontage that the owner has to deal with. Number three, because of these conditions, the application of this ordinance to this particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. This one's a little bit more difficult to ascertain, but given that the property is used in a way to where the frontage along Rifle Range Road is essentially a backyard with the way the fencing and usage of the property has occurred over the years, I would argue that it is not unreasonable to allow the pool and other structures to fit within the setback. 4, the authorization of a variance will not be substantially detrimental to the adjacent property or to the public good, and the character of the zoning district will not be harmed by the granting of the variance. We haven't had any opposition to this request, so I don't believe the neighborhood is upset about it, or the neighbors. 5, the Board of Zoning Appeals shall not grant a variance, the effect of which would be to allow the establishment of a use not otherwise permitted. The property will continue to be used as a residence, so it meets this criterion. 6, the need for a variance is not the result of the applicant's own actions. While this is a little more harder standard to overcome, again, with the way the property has been set up and structured over the years, the privacy related to that area along Rifle Range Road, I do not believe that the applicant I believe the applicant should be allowed to utilize this area for their pool structure. And 7, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. I do not believe this would be detrimental to Charleston County's goals with the ordinance. So for those reasons, I feel that this variance should be granted.
Mr. Nelson, what about the other one? The other condition? Staff recommendation.
Yeah, I was about to add the recommendation that the applicant shall obtain zoning and building permits for the structure.
Thank you, Mr. Nelson. Do we have a second?
Second.
Ms. Lettner, thank you so very much for your second. Very good, folks. Now that we have a motion that's been properly moved in second, I'd like to bring it to a vote. All those in favor, please indicate by saying aye and raising your right hand.
Aye.
Aye. Any opposed? You have the same right. It passes unanimously. Ms. Herbert, congratulations. Within 10 days, you'll receive documentations from the planning staff to let you know the next step in the process. Once again, congratulations. Moving forward, the next case BZA 07-20-00405. And that case will be presented by Mr. Downey.
The applicant and property owner, Melissa Paps, is requesting a special exception to establish a short-term rental, extended home rental, in the single-family R4 zoning district at 2149 Medway Road, TMS number 34306000140, on James Island in Charleston County. The subject property and the properties to the north, south, east, and west are located in the single-family R4 zoning district. The property contains a 895 square foot bungalow-style home with 3 bedrooms that was constructed in 1942 per Charleston County records. The applicant's letter of intent states that this 2-story residence has 2 bedrooms with the ability to accommodate 4 persons, 1 loft with the ability to accommodate 2 persons. This property also includes 5 parking spaces and 3 sleeping rooms with a total maximum occupancy of 6. Currently, the subject property is in site plan review ZSPR 0420000466 for the proposed use. The applicant's site plan review the applicant's STR property zoning permit application states that a maximum of 3 bedrooms will be rented and 5 parking spaces will be available as shown on the proposed site plan, and the property will be non-owner occupied. Staff conducted a site visit on August 12, 2020. The Board of Zoning Appeals may approve with conditions or deny BZA case 07-20-00405 special exception request to establish a short-term rental, extended home rental in the single-family R4 zoning district at 2149 Medway Road, TMS number 34306000140 on James Island in Charleston County. based on the BZA's fact finding unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following conditions recommended by staff. Number one, prior to the zoning permit, the applicant shall complete the site plan review process. Number two, the use shall comply with all requirements of Article 6.8. And number three, the property owner shall be responsible for ensuring the tenant complies with the Charleston County noise ordinance. Next slide. Any questions of staff?
Does anyone have any questions of staff at this time? Very good. Thank you guys for staying in here with us. Is the applicant available, Ms. Working?
Yes, I'm going to promote her to panelist. Okay, Melissa Mathis, can you hear me?
Yes.
Okay, please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And state your full name and address for the record.
Melissa Lynn Mappis, 1157 Pine Arbor Road, Hardyville, South Carolina, 29927.
Okay, Ms. Mathis, thank you for appearing with this board tonight. Please tell us why we should approve your application.
Yes, thank you. I'm requesting this special exemption for a short-term extended home rental located at 2149 Medway Road. Because this house has been family owned since it was built in 1942. My great-grandmother, Bama, first had the home built to raise her family. Since then, the home has been passed down from generation to generation, from Bama to my granddaddy and grandmama, and then to my dad and aunt, and finally, a year ago, to me. As my dad's only child, I know how important this home is to our family's history. Last year, I had the home fully renovated, taking the two-bedroom home that still contained the original furnace from 1942 to a more accommodating residence with the 21st century accommodations. Keeping with the timeline of its construction, the residence has been outfitted with mid-century modern decor as an homage to the Mappis family of the 40s and 50s. The most significant reason for my enthusiastic support of this request for the special exemption is that this residence was renovated for the entire purpose of renting to financially support my aging grandmama and aunt. Living nearby on the opposing side of Maybank Highway, also in Riverland Terrace, my grandma and aunt have not worked for their entire lives, and their source of income is Social Security and the proceeds from this rental. When discussing whether or not to sell one of the last remaining memories of our family in Charleston, I promised them I would do everything possible to care for them and honor the Mappis family with the renovation and rental of this residence. Moreover, since the completed renovation, the residence has proven to be successful in providing those relocating to the Charleston area a welcoming introduction to South Carolina. Twice in the past 6 months, the residence has accommodated long-term renters, first providing housing for a long-term corporate rental to a golf management company based out of Jacksonville Beach, Florida. Second, the residence provided temporary housing for a family of 5 who have just relocated from El Paso to Charleston for job placement. And this has been a welcome start while they search for a home to purchase in the Charleston real estate market. In both instances, the residence was fully furnished with every available accommodation to include a welcoming package, instructions for using smart technology appliances, locks and thermostat, and information on the local market of the Charleston area. Pertaining to the criteria outlined in section 3.6.5 of the ZLDR, the residence is in an R4 zoning district of Riverland Terrace neighborhood on James Island, a neighborhood that contains multiple other permitted short-term extended home rentals. This property and corresponding STR listing is designed to target families visiting the Charleston area, which ties in well with the fabric of this neighborhood. The residence has ample off-street parking spaces with space for up to 5 vehicles. There's a 6-foot privacy fence bordering one of the neighboring properties and mature landscape screening and chain link fence bordering the other 2 neighboring properties, providing any residents and occupants the necessary privacy that they would desire. Thus far, with both long-term rentals, I have taken extra precaution to vet potential guests to ensure they are a good fit, explicitly stating Riverland Terrace is a quiet neighborhood. Even when renting this property, I am readily accessible for any and all concerns. Recently, I had to respond promptly to the current tenant's concerns about pest control and an HVAC servicing, providing them professional assessment and correction of the issue in less than 24 hours. Furthermore, it's extremely important to me that my neighbors are also content and happy with my property operating as an STR. That is why I have contacted many of my neighbors directly to provide my contact information in the off chance there is ever any issue or if they need to reach me for any reason. I'm a huge proponent of the neighborhood and understand the importance of maintaining a family-friendly atmosphere, inviting neighbors to tour the house and to get to know me a bit better since I do not currently live in the Charleston area. Lastly, and with consideration to the ever-present pandemic, the residents will provide another outlet for out-of-town guests to stay comfortably, only further benefiting the local commerce of James Island and neighboring communities. Provided with thoughtful accommodations and concerns for their health and well-being, guests will have at their disposal cleaning supplies, disinfectants, and other items that will ensure their safety while staying at the residence. Following the departure of each guest, the residence is thoroughly cleaned from top to bottom, and it's no surprise that local hotels and resorts will be challenged with solutions to provide their guests outlets for dining that can provide the safety and comfort of home. With the residents, guests will be able to rest easy and comfortably, staying at their home away from home. As a native Charlestonian with many generations tying me to the James Island community, I am looking forward to the opportunity to provide those visiting from out of town a little taste of Southern hospitality in one of the most recognized areas of Charleston, only minutes away from every attraction that Charleston offers. Thank you sincerely for your time and consideration.
Thank you so very much. Does anyone have a question of the applicant?
Do it again.
And then, oh,
There you go.
okay, so it's unmuted. Okay. Does anyone have any questions of the applicant? Can everyone hear me?
We can hear you.
Oh, okay, very good. I thought I muted myself. Well, Ms. Mathis, since no one has any questions of you, once again, we want to thank you for your testimony today.
Thank you.
Ms. Working, do we have anyone that would like to speak in favor of this application?
No, I was going to go over 2 letters we received, and we do have 2 speakers signed up in opposition. On Friday, you received a letter from Catherine Carlick, 2144 and 2146 Medway Road. You did receive a additional letter from the applicant, Melissa Mathis, that was in support. There was one from Shurna Bednarsh at 2151 Medway Road, and this was one you received Friday as well. She is in support of long-term rentals, but not short-term rentals, and was concerned about cars. We have, and then Kaylee Porter, she also submitted a letter in your packet that you received Friday, but she's going to speak after Mrs. Skinner. So if you're ready, I can get Ms. Skinner on. Okay, Mrs. Skinner?
Yes.
Okay. Please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And then state your full name and address.
My name is Pam Skinner, 1437 Fairview Plantation Road, Wadmalaw Island, and I'm on this call today to speak not necessarily in opposition to this particular person, but my request is that I do not feel that this applicant meets all of the criteria that was set out. And I don't have in my 2 minutes time to go through all of them, but criteria 1 is that it's consistent with the recommendations contained in the comp plan, and that this is a single family R4 zoning district. And I get and I understand the R4 zoning district, but where I'm a little confused on this criteria, because I do not think it meets this one particular, I don't think it meets any of them, but the one, this is the first one, is that this is a neighborhood. This is a unique and historic neighborhood. You have Fort Pemberton down at the end. That's part of the National Trust. And when I looked up Riverland Terrace, Airbnb, and other types of rentals, I found 65 rentals for short term in the Riverland Terrace area. And I feel like the short-term ordinance was designed to protect these residential neighborhoods from becoming non-owner occupied rental houses. The residents of Riverland Terrace have fought very, very, very hard to stop SCE&G previously, and now Dominion Energy, from tearing up their trees and trying to get their lines buried. And it's a very complex neighborhood in that you have incorporated and unincorporated parts of Riverland Terrace that all sit in the same neighborhood. And I just feel like the trees that are in this neighborhood and the way the parking is designed in this particular application is just not conducive to a residential neighborhood. And to me, that granting all of these extended home rentals, which are non-owner occupied, we are losing what we need to protect historic districts.
Thank you so very much for your testimony, Ms. Skinner. Does anyone have any questions for Ms. Skinner? Hearing none and seeing none. Once again, Ms. Skinner, I thank you for your testimony tonight. Ms. Workin, do we have any other individuals?
I'm getting Kaylee. Oh, wait, where did she go? Oh, here she is. I see her. Okay. I'm promoting Kaylee Porter to panelists. And can you unmute, Kaylee?
Yes.
Okay.
Can you hear me?
Yes. If you can please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Okay. And state your full name and address.
Kelly Porter, and I live on 2142 St. James Drive, Charleston, South Carolina.
Thank you, Ms. Porter. Please tell us why you're here tonight.
Riverland Terrace's reputation is jeopardized by the increasing potential of non-owner occupied STRs. It is my opinion that allowing a special exemption for 144 nights will adversely affect the character of Riverland Terrace. This will allow for more transient density in a historic residential neighborhood that is not a part of a mixed-use suburban type area. Riverland Terrace is not urban. It is a quiet, single-family residential neighborhood that prides itself on being just that. We do not have an HOA to manage these uses, so we are relying on the county to make sure the character and charm of our neighborhood remains intact. Therefore, I do not believe the applicant meets criteria 1 or 2. The driveway is extremely narrow and the homes on Medway are very close to each other. Another STR in Riverland Terrace, which recently requested a special exemption, has had many issues with neighbors regarding noise, parties, and road congestion from short-term renters, resulting in the police being called. These issues from SDRs affect neighbors' quality of life and property values. Since the applicant does not live nearby, if there is an issue with noise, vibration, traffic, or parking, it would be extremely difficult for any remediation to occur in a timely and orderly fashion. Due to these reasons, I do not believe that criteria 3 is met. Per the applicant's own letter of support, as this letter was not provided as a letter of intent, it mentions that this is a way to provide additional sources of income for the applicant's elderly grandmother and aunt. Based on the applicant's VRBO listing of $130 per night, it is hard to understand this argument, as an accepted long-term lease would provide significantly more revenue and incur much less fewer operating expenses based on the average cost per month in my neighborhood. As mentioned in the applicant's VRBO listing, renters can enjoy the playground area and canopy of 100-year-old live oak trees, which are located on different streets in Riverland Terrace, thus increasing vehicular and pedestrian traffic on adjacent roads. The applicant also mentions that this neighborhood is one of the hottest in Charleston. Therefore, I do not believe that criteria 6 is met. Based on these details, I ask that you deny this application. Thank you so much for your consideration.
Thank you so very much, Ms. Porter, for your testimony tonight. Do we have any questions for Ms. Porter? Does anyone on the board have any questions of Ms. Porter? Thank you once again, Ms. Porter. Ms. Workin, any more?
That's it, just the rebuttal.
Okay, thank you for that reminder. So, Ms. Mathis, you have 2 minutes for rebuttal.
Put her back on.
Yes, thank you. And I would like to clarify as well that in the letters that were received on Friday, we actually, the one that was mentioned from Cherna Bednarz was actually in support of us having this exemption. Ms. Working said that it was not in support of us having that short-term rental, but in fact it is. And she is our direct neighbor. For the concerns of increased traffic, there is anticipated to be no significant increase in vehicular traffic than if the residence was occupied by a long-term tenant. In fact, statistically, long-term tenants have more vehicles per household than with transient tourism. According to the Bureau of Transportation Statistics in the US, there's an average of 1.97 vehicles per household, which increases dramatically if they have 5 or more persons in that household. However, with transient tourism, according to the Bureau of Transportation Statistics, there's actually an average of 1.12 vehicles per household when vacationing. So these statistics would actually suggest that a lesser number of vehicles will be located on the streets and at the residence if it's used for transient tourism than if it were to have long-term tenants. In regard to our listing on Verbo with the calculated rate per night, obviously that rate is based upon a 29-day stay or longer and can be adjusted at a whim if we were to be granted this. Also, the rent obtained on a monthly basis per Ms. Porter's suggestion is actually less than what would be given under a Verbo rate, even using the quoted rate that she provided of $130 per night. Though I do not currently live in Charleston, my entire family, not just those I'm financially supporting with this house does, my parents and my in-laws. From door to door, I can be there in 95 minutes and have done so myriad time in the past year. So I do not believe that to be a problem. I work remotely from home and have a lot of flexibility with my full-time job, as well as my husband who can come as well. The improvements that were made at this residence, I believe, actually have made the neighborhood better. As my neighbor Cherna said in her letter, this house was very dilapidated and was being occupied by somebody who actually was not even paying rent reliably to my family before I became involved. So I actually feel that through this rental, I'm able to provide them a better quality of life, as well as give to the local economy. I have hired a local person who can also respond and has responded to many maintenance requests that we have had, as well as a sole proprietor who mows the lawn of our home and several other homes on the street. And using the economic principle of the multiplier effect, my directly giving this money to other local residents will keep it in the economy, and it will be used multiple times over as it changes hands. So I do hope that you guys will consider to continue and possibly grant this exception.
Thank you, Ms. Masters, for your time. Thank you. Board members, do we have any other questions from this last testimony? Very good. This case is closed to the public, and now we need to make a motion concerning this application. Do we have anybody that would like to make a motion regarding this application?
I'll make it.
Thank you, Mr. Woodall.
All right. In reference to BZA case 0720004005, request for special exception to establish short-term rental. I make a motion that we approve the special exception as it meets all the criteria, that it is consistent with the recommendation, 3651 it is consistent with the recommendation contributed by Charleston County Comprehensive Plan and zoning, and is incompatible. Number 2 is compatible with the existing uses of the vicinity, will not adversely affect the general welfare of the character of immediate community. I believe that it is compatible and that it will not adversely affect, as stated, as it has enhanced and been renovated and brought back up to code. Number 3, the adequate provisions are made such for setbacks and buffer, including fencing, landscaping, protecting adjacent properties and possible adverse influences. It's in site plan review. So that one is, they're going to make sure that they comply with that. Number 4 is developed in a way that will be preserved. Since there's no changes, there's not going to be any, there's no changes proposed on the site, so therefore it meets the criteria. Number 5, complies with applicable rules and regulations. Here again, as stated by staff, it is in site plan review, and they will make sure that they do that. Number 6, vehicle traffic, pedestrian movement on adjacent roads shall not be hindered or endangered. I don't believe that it's going to add any more any cars to it. I'd also include staff's recommendations of the 3 prior to zoning permit approval. The applicant shall complete the site plan review, and the use shall comply with requirements Article 6.8. Property owners shall be responsible for ensuring tenants comply with Charleston County noise ordinance. That is my motion.
Thank you, Mr. Woodall. Do we have a second? I'll second it. How about that? So we have an application that's been properly moved and second. Let's bring it to a vote. Ms. Working, you want to call the roll? Change it up a little bit.
Sure. The motion is to approve with conditions?
That is correct.
Okay. Mr. Ray?
Aye.
Ms. Lechner?
Aye.
Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Freeman? Mr. Freeman, please unmute. Mr. Goldstein? Where did these people go?
Aye.
Okay. Mr. McConnell,
Aye.
Mr. Nelson,
Aye.
Mr. Woodall.
Aye.
Okay, Mr. Freeman, can you unmute? Or are you frozen? He looks kind of frozen again. I bet he has bad internet service. Mr. Freeman, can you hear us?
We can't see him either. Can you see him?
I can see him, but he looks frozen.
Oh, I was about to tell him give us a thumb up or down.
Yeah.
Scroll down with that arrow.
So
Yes, he's frozen.
but so it passes 8, and we could say he abstained. I don't know what do you want me to do?
Well, it passes basically because we have I won't say unanimous vote, but
Yeah.
since he's not able to vote,
I'll just mark him as abstained.
pass.
Okay. Oh wait,
It passed.
there he is.
Hey!
All right.
Welcome back,
This stuff is the thing about me.
Mr. Freeman. How do you vote on the motion? Did you hear the motion?
Yes, I did.
Okay.
I heard you. Okay, but aye.
Okay.
I'm for it.
Okay, so it's unanimous for approval with conditions.
Very good. Good. Thank you. So, Ms. Mathis, congratulations. Within 10 business days, you'll receive a certified letter from staff stating the next point in the process. Congratulations once again.
Thank you very much. Thank you all.
Very good. All right, guys, we're at the bewitching hour of 8 p.m. We have 2 more cases ahead of us. Our next case is case BZA 07. 3. Oh, gosh.
Let's not forget our last one. He's waiting on
3 cases. 07-20-00406. And that case will be presented by Mr. Downey.
The applicant and property owner, Tina Johnson, is requesting a special exception to establish a short-term rental, extended home rental in the single-family R4 zoning district at 1920 Sunnyvale Road, TMS number 35515000005 in the St. Andrews area in Charleston County. The subject property and properties to the south and west are located in the single-family R4 zoning district. The properties to the north and east are located in the city of Charleston's jurisdiction. The property contains a 1,296 square foot, 1-story ranch-style home with 3 bedrooms that was constructed in 1971 per Charleston County records. The applicant's letter of intent states we will be renting out 4 bedrooms and allow up to 9 people to stay in the house for up to 144 days a year. Currently, the subject property is in site plan review process, DSPR 0520000472 for the proposed use. The applicant's STR property zoning permit application states that the maximum of 4 bedrooms will be rented and 8 parking spaces will be provided as shown on the proposed site plan, and the property is currently owner occupied. Staff conducted a site visit on August 12, 2020. The Board of Zoning Appeals may approve or approve with condition or deny BZA case 07-20-00406. Special exception request to establish a short-term rental, extended home rental in the single-family R4 zoning district at 1920 Sunnyvale Lane, TMS number 35515000005 in St. Andrews area in Charleston County, based on the BZA's fact finding, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application the board should consider the following conditions recommended by staff. Number one, the zoning permit. Prior to the zoning permit approval, the applicant shall complete the site plan review process. Number two, the property shall comply with all requirements of Article 6.8. And number three, the property owner shall be responsible for ensuring that all the tenants comply with the Charleston County noise ordinance. Any questions of staff?
Thank you, Mr. Downey.
Thank you, Mr. Ray.
It's working. Is the
Yes.
applicant available?
Yes, it's Tina Johnson. I'm going to promote her to panelist now.
Hello.
Hi, Tina. If you can, please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thanks. And state your full name and address for the record.
My name is Tina Christine Johnson, and my address is 1920 Sunnyvale Avenue, Charleston, South Carolina, 29414. Can you hear me?
Okay, Ms. Johnson.
Okay.
Yes, we can hear you. Thank you for coming before this board. Please tell us why we should approve your application.
Okay. My name is Tina Johnson. I'm applying for a special exception to establish an extended short-term rental at 1920 Sunnyvale Avenue, Charleston, South Carolina, 29414. Before relocating to Charleston, I operated a short-term rental in Omaha, Nebraska. It was an exciting and positive experience. This rental allowed me to maintain an income while I completed my college degree as a physical therapist assistant. I am currently employed at MUSC in West Ashley as a PTA. Because of health concerns that are progressive in nature, it has again become vital to establish a secondary income source to ensure I can remain in my home in the future. I sought out a home in Charleston County because there were no restrictions on short-term rentals at the time. I successfully hosted over 100 groups of guests without a single incident before being informed that Charleston County had enacted regulations on short-term rentals. Up until today, I had not heard a single complaint from anyone in the neighborhood concerning any aspect of my operation. When I was informed a neighbor had voiced concern about future rental guests, I immediately called her and spoke with her for 26 minutes. I addressed her concerns, and afterwards she stated she felt better about my plans. Because of my extensive prior experience with short-term rentals, I believe the probability of adverse effects to be quite low. I have also taken many steps on my rental to limit potential for negative impacts on my neighbors and my community. I installed a second paved driveway to limit impediment to traffic flow. I have a privacy fence around the entire backyard for noise control. I instruct guests to limit noise after 10 p.m., and I have a strict policy against parties of any kind. I anticipate the opportunity to continue sharing my love for Charleston County and the businesses here with all of my guests. I would like to thank everyone with the zoning and planning departments that have assisted me in order to get to this point, and I look forward to completing the process. Thank you.
Thank you, Ms. Johnson, for your testimony tonight. Board, does anyone have any questions of the applicant? Any? Very good. Thank you, Ms. Johnson, for your testimony tonight.
Thank you.
Ms. Workin, do we have any other people to speak in favor of?
I apologize. I didn't mean to mute you. So we don't have anyone to speak in favor or in opposition, but like she mentioned today, I spoke to the neighbor, Frances Waits, an elderly lady that couldn't be on Zoom tonight. And they since talked and have addressed all the concerns that she had. So.
Very good. Thank you so very much, Ms. Working.
Welcome.
Board, at this time, I'd like to close, Ms. Lettner, you have a question?
I was going to make a motion.
Okay.
Moving it
At
along.
this time, I'd like yes, at this time, I'd like to close this case to the public. And Ms. Lettner, if you could, please, ma'am, make a motion for this application.
Gladly. In regard to case BZA 0720000406, I'd like to make a motion that we that we approve a special exception based on the following criteria. Criteria 1, it is consistent with the recommendations contained in the Charleston County Comprehensive Plan and the character of the underlying zoning district. Criteria 2, is compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. Criteria 3, adequate provision is made for such items as setbacks, buffering, including fences or landscaping, to protect adjacent properties from the possible adverse influence of the proposed use. Criteria 4, will be developed in a way that will preserve and incorporate any important natural features. Criteria 5, complies with all applicable rules, regulations, laws, and standards of this ordinance. Criteria 6, vehicular traffic and pedestrian movement on adjacent roads shall not be hindered or endangered. And I also would like to include the 3 recommended conditions as listed and outlined by staff.
Thank you so very much, Mr. Lettner, for your motion. Do we have a second?
Second, Mr. Chair.
Okay, I heard Mr. Goldstein first, but I saw Mr. Borkin's hand first. So I don't know how we can split that. How about Mr. Borkins will make the second on that one. Ms. Working, if you would, please call the roll for the vote.
Okay. Mr. Ray?
Aye.
Ms. Lettner?
Aye.
Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Freeman?
Aye.
Mr. Goldstein?
Aye.
Mr. McConnell?
Aye.
Okay. Mr. Nelson?
Aye.
And Mr. Woodall?
Aye.
Okay, it's unanimous approval with 3 conditions.
Thank you, Ms. Working. Moving right along. Our next case tonight is case BZA-07-20-00407. This application will be presented by Mr. Edgar Sada.
The applicant and property owner, Emily Adams of Twin Oaks, Maybank LLC, represented by Mike Johnson of Fosberg Engineering and Survey Inc., is requesting a variance for the removal of a 27-inch diameter breast height DBH Grand Pecan tree for a proposed office building at 3430 Maybank Highway, TMS number 279-00-00046 on Johns Island in Charleston County. The subject property and adjacent properties to the north, south, and west are located in the MHCO Maybank Highway Corridor Overlay Commercial Transitional Zoning District. The adjacent property to the west is under the jurisdiction of the City of Charleston and is Zone General Office. Charleston County Zoning Land Development Regulations Ordinance, Chapter 9, Development Standards, Article 9.4, Tree Protection and Preservation, Section 9.45. Tree removal be variances, grant trees, and protected trees that do not meet the above criteria, Section 9.4.5a, may be removed only when approved by the Board of Zoning Appeals and shall be replaced according to a schedule determined by the board. The planning director will make recommendations to the board concerning the number, species, DBH, or caliper, and placement of such trees. Currently, the subject property is in the site plan review process for the development of a proposed 5,000 square foot office building of the vacant 2.028 acre property. Out of the 2.028 acres, 0.581 acres are freshwater wetlands. The 27-inch DBH Grand tree is located behind the proposed building in a portion of the proposed parking lot. The plan also depicts a proposed 4,000 square foot phase 2 feature office building. Zelda requires 1 parking space per 300 square foot of floor area. Staff conducted a site visit on August 11, 2020. These are pictures provided by the applicant of the Grand Pecan tree. Subject property, surrounding properties, Maybank Highway. And in order to save time, I would say that we should look at criteria 3 and criteria 6, that they may not meet these criterions. In the event the board decides to approve the application, the board should consider the following conditions recommended by the staff. Condition 1, the applicant shall mitigate the removal of the 27-inch DBH Grand Pecan tree by either A, submitting a mitigation plan for review and approval indicating the installation of canopy trees no smaller than 2 1/2 inches in caliper, equaling inch per inch replacement. B, by depositing funds into Charleston County Tree Fund as described in section 9.46 of the Charleston County Zoning and Land Development Regulations. Or C, combination of both A and B. Documentation of the allotted mitigation shall be submitted, reviewed, and approved for the tree prior to its removal. 2, prior to zoning permit approval, the applicant shall install tree barricades around the grand trees to be preserved pursuant to section 9.44 of the Charleston County Zoning and Land Development Regulations. 3, prior to zoning permit approval, the applicant shall complete the site plan review process. There's a survey, a site plan, plat. Are there any questions?
Thank you, Mr. Sada. I don't think anyone has any questions of you at this time. Good job, too. Ms. Perkins, is the applicant available?
Yes, there's actually 2 Emily Adams. So I don't know which was which. And then Michael Johnson's also on, and we don't have any other speakers. So I'm just going to try this first, Emily.
Good evening.
Hi, Emily. Did I pick the right one?
Yeah, you did. I couldn't figure out how to get the microphone on my laptop to work.
Okay. Please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Okay, and then state your full name and address for the record.
Emily Adams of Twin Oaks Maybank LLC, 3575 Maybank Highway, Suite H, Johns Island, 29455. I'm Emily Adams. I'm attending tonight with my husband, Nick Adams, and we are the owners of Twin Oaks Maybank LLC. I'm better known in the Johns Island community as Emily Adams, State Farm Agent, and our office is currently located in the Bilo Shopping Center. Having our own location along the Maybank Highway has always been a dream of ours since we opened our agency on Johns Island more than 5 years ago. Since acquiring this piece of property late last year, we have been working diligently with the county to develop a thoughtful and practical site plan to make this dream become a reality. This modest property, like many of its surrounding neighbors, is long and narrow with undevelopable wetlands in the back. Because of these components, we are extremely limited on building, driveway, and parking placement. After careful consideration of countless site plans, the variance that we are presenting, which is the removal of one grand pecan tree, is the most advantageous and least invasive of all. We take great pride in the beauty and nature that is Johns Island, and we want nothing more than protect that and incorporate it into our development. We have gone through great efforts to not only preserve the grand trees on the property, but highlight them. In fact, the name of our company was derived from 2 of the grand oaks that sit along front of the property, and partially because we had twin boys in August. We are excited about the opportunity to make them the feature of this property. And it is believed, even by the arborist, that some of these live oaks would even thrive with the pecan tree removal. If the pecan tree is not removed, its close proximity to our building, parking, driveway, and customer walkways will present a current and future danger to all parties involved. In talking with several contractors and arborists, it is not a matter of if the pecan tree has limb failure, it's a matter of when. Pecan trees have a high proclivity for limb failure, and as an insurance agent, liability and risk are always on my mind, especially in an area prone to catastrophic wind events. Approval for removing this pecan tree will help the other grand oaks to thrive while at the same time reducing risk to the building, cars, and most importantly, people. Moving the building, parking areas, driveway, and our customer access further away from the pecan tree is not practical because of the property size limitation. Increasing the distance from building to parking areas would be detrimental to the elderly and disabled customers that we serve daily. Maintaining the natural beauty and habitat that our community on Johns Island is known for while serving our customers in an efficient and safe manner is our utmost priority. We thank you for your consideration in this matter.
Well, thank you, Ms. Adams, for your testimony today. Board, does anyone have any questions of Ms. Adams? I know we're tired, but does anybody have any questions of the applicant? None. Thank you so very much, Ms. Adams, for your testimony tonight. Ms. Working,
Okay.
do we have any other individuals in support?
Yes, I think Michael Johnson would like to speak in support for 2 minutes. Michael, can you unmute? Okay, there we go. Hi, Michael, can you hear me?
Yeah, I can. Can you hear me?
Yes. Please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you.
Well, Emily did a great job going over what we're trying to do out here, so I can keep this pretty short. I do want to thank the board for their time and consideration. I know it's getting late, so this will be brief. And I wanted to also thank the planning department. They worked with us to get to this point, and we went through numerous site layouts to minimize the impact that our development on the trees. With staff's assistance, we worked around the other 10 grand trees on site. We're requesting the removal of this 27-inch pecan tree because it is a hazardous tree. And I just wanted to touch on 2 of the criterion that the county felt that we may not be meeting. Criterion 3 says because of these conditions, the application of the ordinance to this particular piece of property would effectively prohibit or unreasonably restrict utilization of the property. It's our opinion that applying the ordinance to a tree that poses a risk to the public is an unreasonable restriction of that parcel utilization. Now, if the tree is not granted a variance for removal, we'd need to restrict that access under the uneven canopy to avoid liability. And the space is just wasted on a tree that honestly just isn't very aesthetically appealing. As far as criterion 6, the need for the variance is not the result of the applicant's own actions. It's our opinion that we do meet this criterion based on the request to remove a hazardous tree. The tree was not the result of the applicant. And this is more in line with the owner being responsible, a responsible property owner. And thank you.
Thank you, Mr. Johnson. Does anyone have any questions of this, Mr. Johnson? None?
I don't think we got his name and address.
Mr. Johnson, we didn't get your name and address, I believe.
Mike Johnson, Forsberg Engineering, 601 Meeting Street, apartment 5099.
Thank you, sir. Ms. Workin, do we have anybody else to speak in favor or opposition?
Nope, that's it.
All right, folks. At this time, I'd like to close this application. Wait a minute, we didn't have any opposition. No. At this time, I'd like to close this case to the public and make a motion, not make a motion, but ask if anybody would like to make a motion for this case. Oh, Mr. Borkins.
I'll be happy to.
Thank you, sir.
In the case number BZA 0720000407, I move to grant the variance to remove the 27-inch diameter breast height grand pecan tree. I find it meets all of the criteria, all 7 of them. There are extraordinary and exceptional conditions pertaining to this particular piece of property. It's a very long and narrow lot. It has 11 grand trees. It is a commercial lot. It obviously has to meet all the requirements for access and parking, as well as the commercial space itself. I find it meets criteria number 2, that these conditions do not generally apply to other property in the vicinity. This is an exceptionally heavily wooded lot. So I think that makes a difference in its narrow size and the fact it's a commercial use. As to criteria number 3, because of these conditions, the application of this ordinance, this piece of property would effectively prohibit or unreasonably restrict the utilization of the property. In this case, it's more of an unreasonable restriction. This particular tree is a hazardous tree. It's in an area that's going to be required for parking. The fact that this particular applicant is basically saving 10 of 11 trees, and that some of the other live oak trees will benefit from the removal of this particular tree, are all reasons that this applies. Criteria 4, the authorization of variance will not be a substantial detriment to adjacent property or the public good, or the character and zoning of the district will not be harmed by granting the variance. Again, it will be consistent with the character and culture of Johns Island and that commercial district, as they are saving the lion's share of those trees. For 5, the Board of Zoning Appeals shall not grant a variance, the effect of which would be to allow the establishment of use not otherwise permitted in the zoning district, or to extend physically a non-conforming land, or to change the zoning district boundaries shown on the official zoning map. It doesn't do any of that. It's being used as a commercial lot, and it's been well planned and thought out well by the engineer. Criteria 6, the need for the variance is not a result of applicant's own actions. The lot itself, it's narrow and long length, and the amount of grand trees on the property, I believe, contribute greatly to creating the need for the variance, more so than the applicant's own actions. Finally, criteria 7, granting of the variance does not substantially conflict with the comprehensive plan for purposes of this ordinance. It does not. The tree is actually, there's a report saying it's hazardous. So, I mean, removal of the tree would almost have been something that the planning director could have applied almost. Anyway, I will attach the criteria that recommended by staff. Number 1, the applicant shall mitigate removal of the 27-inch DBH grand pecan tree by either A, submitting a mitigation plan for review, and approval indicating the installation of canopy trees no smaller than 2 1/2 inches in caliper, equaling inch per inch replacement, by depositing funds in Charleston County Tree Fund as described in Charleston County Zoning Land Development Regulations, or C, a combination of both A and B. Documentation of the allotted mitigation shall be submitted, reviewed, and approved for the tree prior to its removal. Number 2, prior to the zoning permit approval, the applicant shall install tree barricades around the grand trees to be preserved pursuant to section 9.4.4 of the Charleston County Zoning and Land Development Regulations. And finally, number 3, prior to zoning permit approval, the applicant shall complete the site plan process.
Thank you, Mr. Watkins. Do we have a second? Mr. Woodall, did I see your hand? I also saw Mr. Nelson's hand. Thank you. It has properly been moved and seconded. Ms. Workin, would you please call the roll?
Sure. Mr. Ray?
Aye.
Ms. Luckner?
Aye.
Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Freeman?
Aye.
Mr. Goldstein?
Aye.
Mr. McConnell,
Aye.
Mr. Nelson,
Aye.
and Mr. Whittle.
Aye.
Okay, it's unanimous for approval with the 3 conditions.
Congratulations, Ms. Adams, on getting your application approved. Within 10 business days, the county staff will send you a certified letter letting you know the next step in the process. Once again, congratulations on your endeavors and this application. Okay, ladies and gentlemen, we're down to the very last application tonight. Tonight we have case BZA 07-20-00408. And then finally, this application will be submitted by Mr. Edgar Sada.
Bring her home. So the applicant and property owner, Sonia Whaley Simmons, is requesting a variance to reduce the required 15-foot interior side setback by 10 feet to 5 feet for a proposed residence at 1670 Elias Lane. TMS number is 334-0400-062 on James Island in Charleston County. The subject property and surrounding properties to the north, south, and east are located in the Special Management 3S3 zoning district. The property to the west is located in the Low Density Manufactured Housing Subdivision (MHS) zoning district. The property owner would like to build a retirement home on the vacant 0.85 acre property. The Charleston County Zoning and Land Development Regulations, Chapter 4, Base Zoning Districts, Article 4.9 S3, Special Management 3 District, Section 4.93, Density, Intensity, Dimensional Standards requires a 15-foot interior side setback. Here's the vacant lot. Staff conducted a site visit on the subject property on August 11th, 2020. This is the subject property. Surrounding properties. Last lane. We'd like to point out a couple of criteria that it does not meet. Criteria number 2, these conditions are not unique to the subject property and generally apply to other properties in the vicinity. Therefore, the request does not meet criteria. This is criteria number 2. And criteria number 6, the need for the variance is the result of the applicant's own actions because of the desired size and placement of the residence, garage, and driveway. Therefore, the request does not meet this criterion. However, the applicant's letter of intent contends, we've had this house plan for a couple of years and would love for this to be our new home. The variance is needed to accommodate the side load entrance of the garage. There's no attached conditions. Site plan. Plat. Any questions to staff?
Thank you, Mr. Sada. Ms. Workin, is the applicant available?
Yes, she is, and she is the only speaker for this request. Sonia Simmons, I'm promoting her now. Sonia, if you can unmute.
I just did.
Okay. Please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Okay, thank you. And please state your full name and address for the record.
Sonia Whaley Simmons, 1438 Folly Road, Charleston, South Carolina, 29412.
Good evening, Ms. Simmons.
Hello.
Please tell this board why we should approve your application. Please, ma'am.
We're asking for a variance due to the fact that we've found a house plan that had basically everything that we were looking for in our new home. We would like this to be our retirement home, which my husband and I we're planning on retiring within about 2 to 3 years for both of us. And the parcel across the front is a bit narrow due to where the plan is designed with the side loading garage and with the 15 feet setback that won't allow us to turn into the garage. And prior to all of this, when we selected that house plan, we both were unaware or ignorant to the fact that setbacks existed. We just thought that if the plan was smaller than what the width of the property was, that everything would be okay. And we just recently discovered that you have setbacks and guidelines, which we were unaware of.
Okay, thank you. Hold tight. Does anyone have a question of Ms. Simmons, the applicant? Mr. Boykin.
Yes. Good evening, Ms. Simmons. How are you?
I'm fine. How are you?
Doing just fine. Have you had a chance to speak with either of your neighbors that are listed here on the plat, Ms. Clara Arthur or Ms. Carolyn Adams, about your plans for your new home?
I did. I spoke with both of them.
Are they okay with it?
They are. I think initially the sign went up before I had a chance to speak with them, so they were concerned that we were thinking about putting up something as a rental or commercial. They just saw the zoning and kind of got worried, which is understandable. But after speaking with them and letting them know what our intentions are, they were okay with it.
Okay. All right. That's all I have. Thank you so much.
Thank you.
Thank you, Mr. Boykin. Does anyone else have a question of the applicant? Okay, seeing none. Thank you. And Ms. Workin already stated that we don't have anyone else to speak in favor nor in opposition. That being correct? Thank you.
Yes, that's correct.
So at this time, I'd like to close this application to the public, and I'd like to ask for a motion for support or denial of this application. Anybody want to take us home now? Mr. Freeman, you want to take a shot at it?
I think he does.
He's muted.
Uh-oh. Did he freeze up on us?
Yeah.
Unmuted. Hello?
Hi.
You want to take a shot at taking us home on this one? Giving
Yes.
us a motion?
Yes. Can you hear me?
Yes, sir.
Okay. And case number BZA 0720000408. I would recommend approval based on criteria number 1. There are extraordinary and exceptional conditions pertaining to the particular piece of property. Criteria number 2, these conditions do not generally apply to other property in the vicinity. Criteria number 3, because of these conditions, the applicant's application of the ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. Criteria number 4, the authorization of a variance will not be of substantial detriment to adjacent property or to the public good. Number 5, the Board of Zoning Appeals should not grant a variance, the effect which would be to allow the establishment of a use not otherwise permitted in the zoning district. Number 6, the need for the variance is not the result of the applicant's own actions. I guess it is. Well, it might be the results of the applicant's own action. Criteria number 7, granting of the variance does not substantially conflict with the comprehensive plan or the purpose of the ordinance. Staff has no recommendations, I guess. I guess the staff has no additional recommendations, so therefore we proceed from there. Hello?
Thank you, Mr. Freeman.
Okay.
All right. So we have a motion on the floor. Do we have a second? Mr. Boykin?
Yes, sir.
You got a fast hand there. You just draw real quick. I like that.
We do need to say
So we
how
have-
this meets number 6, if you guys are gonna approve this in discussion.
Thank you, Ms. Workin. Did the board hear that? Mr. Freeman, did you hear that?
Can you repeat it?
In order to approve this application, somebody will need to state how it meets criteria 6.
Oh, I'm sorry. The need for the variance is not the result of the applicant's own actions.
Okay.
Okay. So we still hold on to that second, right, Mr. Boykin?
Yes, we do. And I would add to Mr. Freeman's motion that, you know, the orientation of the driveway, the side load of the driveway, the width of the lot would all contribute to some restriction on that lot that might be taken into account to grant this variance.
Mr. Freeman, you accept that?
Yes, accepted.
Very good. So we have a motion on the floor that has been properly moved to second. Ms. Workin, if you would call the roll for the vote.
Okay. Mr. Ray?
Aye.
Ms. Lechner?
Aye.
Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Freeman?
Aye.
Mr. Goldstein? Mr. Goldstein? Where'd he go?
He's finally silent.
Okay, there he is.
Aye.
Mr. McConnell?
Aye.
Mr. Nelson?
Aye.
And Mr. Woodall?
Aye, and I was just impressed that we finally got Tommy to stop talking by muting him.
I had to put on my glasses in order to see the button.
So
There it
it's unanimous for approval. We didn't have any conditions for that one. So.
Okay. I can see better now.
Ms. Simmons, congratulations. Within 10 business days, you will receive notification from a certified notification from the county office, letting you know exactly what the next steps are in this procedure. Once again, congratulations and good night. Board and Ms. Working, do we have anything else for this august body?
Yes.
I just love that.
So your next meeting is October 5th, 2020, 5 o'clock p.m. We will need to decide really quickly if we want to keep with this format. I felt like it went pretty well, and actually really well. I thought it went really well. We have 8 new cases on the agenda, 5 variance cases, and 3 special exceptions, and all of those are STRs, EHRs. We will have the old business case though. The Bolt driveway variance was added, so that would be 1 old business and 8 new business cases. Does anybody have any comments about the format tonight? I feel like the public seems to be okay with it.
It was great.
Okay.
Jenny, I just want to say I thought y'all did an absolute fantastic job with the execution of it, and I thought it went as smoothly as it could possibly go, and I didn't have any trouble following other than my own ineptitude of operating my MacBook.
Great. Yeah.
That was all Jenny's doing, by the way, guys. So I want to give her.
Oh, we practiced. We recruited a lot of people for practice. Several people played Tommy, so.
That was always fun to play Tommy. He's the best.
Yeah, yeah.
You need to borrow my glasses, Jenny?
Yes, please.
Okay,
But,
I'll bring them by.
So we'll talk it over with our director, but it seems like we probably, as long as school's not in session and as long as we're under an emergency order, we can have virtual meetings. So I'm assuming by October 5th, we're still going to be in an emergency order.
I think you're right.
So, okay, next slide, Edgar. And then just a reminder about training. Mr. Friedman, you just need an hour and a half, and Ms. Lecter and Mr. Ray need 3 hours. So if you need any ideas, just let me know. Everyone else has finished, but it is almost fall. So want to make sure we get those done, and it can be done on your own time at your house or wherever.
Thanks.
That's all I have.
All right, thanks.
You're welcome.
Thank you, guys.
Everybody take care except for Rob.
With that being said, I'd like to say that this meeting was very good. I do appreciate everybody attending and staying aware and alert. And at this time, this meeting is adjourned. Thank you.
Good night, y'all.
Thank you.